But what I have given to you, then you will xerox and give me. Okay, ठीक है. Actually, all this one I don't know.
No, this photo I know, but where is my copy? That day we taken out.
I sent to everybody.
Everybody, but I am not the thief now that I have taken.
By mistake you have taken. It's mine.
Because me, Kepi was here.
When I did it like that. But I marked everything.
May please, Your Lordship. Lordship, I beg to make a mention of item number 11, Your Lordship. Lordship, I pray if this matter may be listed after 2 weeks, Your Lordship, as we need some more time to prepare this matter, Your Lordship.
You're for?
I'm for petitioner, Your Lordship.
On pre-made by the petitioner. This is matter of 2 weeks.
Highly obliged, Your Lordship.
May please, Your Lordship, I beg to mention item number 8. It's a joint request, Your Lordship.
Who's for the?
Sir N.D. Shulai.
Nobody is from side of the state.
We have already taken consent, Your Lordship.
You have taken consent?
Yes.
On pre-made by the petitioner, this is matter up to 2 weeks.
Obliged, Your Lordship.
On daily list, item number 1.
Yes.
May please, Your Lordship. Your Lordship, this matter could come up after 1 week, Your Lordship. As the conducting counsel, has some personal difficulties, Your Lordship.
You're for?
I'm for the respondent 2 and 3, or 1 and 2, Your Lordship, in this matter.
Who's for the state?
And put a private respondent.
Learned AG used to appear. This was the matter regarding Lokaयुcta.
Yes, I understand. The issue of maintenance has been decided. So now we are to
On the main case.
on the
Yes.
So this, I think this matter is okay. Now this matter is posted for admission hearing. It should be posted for hearing actually.
Item 5 is also connected. That is posted for hearing. Item 5. And for the petitioner.
It should be posted for hearing.
Only thing is that why it is put in admission is because that aggrieved person have not filed in that repetition, because there's some other officer, government officer, the case was filed against the private respondent has filed a case against the another particular MDC, the private respondent. That MDC, actually that aggrieved person is the contractor and the MDC. So the order was passed against the contractor and the MDC by the Lokaयुcta.
No, that is true. That is true.
Yes.
That issue would be decided when the matter is heard on merits. See, that point would also be taken into account.
Yes.
So you can raise that issue if you are aggrieved.
If they have not filed any objection to
Yeah, but as of now, you see, if I am not mistaken, the issue of maintainability has been decided. That this petition is maintainable, it is to be heard.
No,
as far as merit is concerned, you can raise all those issues when the merit is taken up.
That maintainability, Lordship, on the other occasion, the other issue is because they have filed the miss case where they are trying to delete the party from the Lokayuta, saying that the Lokayuta should not be a make necessary party. That is decided already. That is already Jasmine also have known.
And the third respondent is the complainant.
Yes, third.
So he is on board.
Yes, on
They are
board.
representatives.
They are who's representing him?
I'm representing.
So you're representing him.
Yeah, I'm representing because the order of the Lokai order of the Lokai was yes.
Exactly,
Yes.
exactly. That matter will be heard. So whether the order of the Lokaयुta has merit or not, that will be heard. So as far as maintainability is concerned, this court finds that this matter is maintainable, can be heard on merit.
Yes,
Now it is fixed on the in the admission hearing stage. So we'll post the matter for hearing.
Your Lordship has decided the maintainability issue. Your Lordship has decided the maintainability matter has to be heard on merit now.
Exactly, that's what I'm telling Mr. Sangwa.
Yes, please. Yes.
On prayer made by parties, this matter is now posted for hearing. List the matter after 2 weeks.
Lordship.
Your Lordship, similar prayer for item number 5, Your Lordship.
But 1 and 5 are on the same issue.
Connected matter, my Lord. 1 and 5 continue.
Katuka 5 days on prayer made by parties, list this matter for hearing after 2 weeks.
Much obliged, Lordship.
Item number 2.
May I please, Your Lordship? In item number 2, I am appearing for respondent number 9.
Yes, Mr. Paske, what is required here?
Yeah, Your Lordship, the respondents were supposed to file the reply affidavit in opposition.
Okay.
I'm praying for 2 weeks' time, Your Lordship.
I'm also praying for 2 weeks. For respondent number 3 to 7.
I'm for respondent number 1 and 2.
What about 8, respondent number 8? Who's respondent number 8? Mr. Counsel?
District Council, Sir Vivan Singh.
None. Yeah. Prayer has been made on behalf of the respondent number 1, 2, seeking time to file the counter affidavit. Similar prayers has also been made on behalf of the respondents 3 to 7. Next. None appears for respondent 8. As far as respondent 9 is concerned, Land Council has submitted that the counter affidavit has since been filed. Have you filed any rejoinder to this?
We'll be filing, Your Lordship, after we have received the counter.
On prayer made by the parties? The prayer made by the parties is allowed. However, the counter affidavit is directed to be filed within the next date fix. This is matter up to 2 weeks.
Item number 3.
Please, my lord. Lord, here the respondent number 2 and 3 were supposed to file their written arguments.
Yes, who's appearing for respondent?
Mr. KP.
He's not here. He's supposed to file the written argument.
My lord.
Has it been filed?
Petitioner here.
I don't think so. So far as the petitioner's lordship, even we have not filed lordship.
Your lordship, we have filed in CRP 28.
Who's for the... Who, okay.
In 21, I have not filed lordship.
This would be in 28. Mr. Bhattacharjee is supposed to file the...
21, in 21.
21,
in
lordship.
21 or 28?
Even the petitioners in 21 has not filed lordship. I'm praying for some time, lordship.
You are for?
For the petitioner in 21.
In 21.
Lordship. I've seen the order sheets. That prayer was not made by us because lordship.
Why are you dealing with this matter?
Lordship. We'll file it within a week's time.
Your lordship, we have filed our written arguments in CRP 28.
28 they are filed.
You are for?
We are the petitioners in CRP 28.
There are two matters, lordship. CRP 21 and 28.
Yes. You are in 21 or 28?
I'm in 21, lordship. She's in 28.
Okay. And Mr. Bhattacharjee is?
In 21 now.
In 21.
He is the petitioner?
No, he's respondent.
Respondent.
For this.
In any case, you have not filed yours.
I have not filed
in
mine
21.
in 21. Lordship.
Mr. M.L. Longpure, Learned Counsel, for the petitioner in CRP number 21 of 2016 has submitted that he may be allowed to file the written argument within the next 8 weeks since the same could not be filed today. The state respondent 2 and 3 in CRP number 21 has also not yet filed the written argument. As far as CRP number 28 of 2016 is concerned, the petitioner therein has filed the written argument. However, you are, Mr. Sama, you are...
My lord, I'm for the respondent.
You have filed your written argument?
No, my lord. Your lordship have order dated 10/5/2024. We're just waiting for the submissions made by the state in item number, my lord, in CRP number 21. Because they have made some they have advanced their arguments, so we just required, my lord. We'll go through it and we'll file it accordingly.
Mr. C.C.T. Sama, Learned Counsel for the respondent, has also sought for time to file the written argument. On behalf of the respondent, number 1 has prayed for the same is allowed. This matter after 2 weeks. And 2 weeks will be enough time for you to, but do it.
2 weeks will
when 2 weeks time is given means enough time is given for you to file.
Lordship, I'm a value pledge.
Item number 6.
Lordship, Learned CGC is on the other side. Learned CGC, Sir Dipnat is on the other side.
CGC? Is that school matter?
Yes, Your Lordship.
No, Miss, have you seen the last order?
I have filed the service affidavit, Your Lordship, on the last date.
Okay. This is for respondent number 4 and 5.
4 and 5. 6, 7, 8 is represented by Sir
6, 7, 8?
It's represented by Sir Dipnat.
Okay. What is required here? Counter affidavit have been filed by the other respondent.
Lordship, in the first, they have already filed on behalf of 4, 5, 7, and 8. But since Learned CGC is not representing anymore for respondent 4, 5, respondent are supposed to file fresh.
Okay, so 6, 7, and 8 have already filed their written argument. Their counter affidavit.
Yes, Your Lordship. For 4, 5, 7, and 8.
So 4, 5, 7, 8, no doubt. But now 4 and 5, have
4 and 5
have to be represented separately.
Separately.
And the counsel for the petitioner has submitted that the respondent 4 and 5, having received notice, have failed to appear before this court today. The Learned CGC appearing for the respondent 6, 7, and 8 is also not present on call. However, the Learned Counsel would submit that the respondent number 6, 7, and 8 have already filed their counter affidavit. In fact, the counter affidavit on behalf of the respondent 4 and 5 have also been filed previously, but under the changed circumstances, wherein the Learned CGC is no longer appearing for the respondents number 4 and 5 respectively. The respondent number 4 and 5 are to seek instruction as to whether the counter affidavit on their behalf would be filed afresh, or the counter affidavit on record would be relied upon. Like, since the respondents 4, 5 as well as the respondents 6, 7, 8 are not represented today, matter is adjourned. Let's see after 2 weeks.
Item number 7.
May I please, Your Lordship? In the last occasion, Your Lordship was pleased to direct me to seek the instruction from the school managing committee regarding whether this post is advertised or not. In this regard, Your Lordship, only yesterday I was informed by the secretary that post was advertised in the newspaper in 2020, but they have not got any instruction for conducting interview. Okay. So post is lying vacant till now. So in this
post lying vacant.
Lying vacant.
It is the post of which
this
against the petitioner.
No, which subject?
She's
is it the post for a particular subject or just generally?
Generally, just
the petitioner was teaching in which subject?
Actually, it's a general. They don't mention any specific lordship.
So generally.
Only general. That the appointment says that he should be. He is not mention any particular subject, but only say that he was appointed. Otherwise, the appointment letter speaks lordship. I have annexed it.
Only it is for for the post of assistant teacher. Only it is written assistant teacher.
How many teachers are there in the school?
How many teachers do you
She's the managing committee. I think she should have the knowledge.
This is for the knowledge of the court.
Yes, Your Lordship.
The court would like to know how many teachers are there. Whether in the event that post is vacant, whether any teacher is taking over the duty or rather additional duty as far as that post is concerned. Otherwise, what happens is the student will suffer. Now that situation it was prevailing since 2020.
2 years, 3 years already, Your Lordship. In this even, Your Lordship, I am
2019,
saying, Your
it's,
Lordship,
from
may
2019.
kindly, pass an effective order so that I can forward it to them, because already I have verbally to through WhatsApp I have sought for all this information, but they have sent me this only advertisement that post is lying vacant, nothing else.
Anyway, that is beside the point.
Yes, sir.
This petition will be heard. If the petitioner succeeds, so be it. If she fails, then the advertisement process that has been initiated would proceed.
Yes, Your Lordship.
Yes.
The only concern now is if somebody has been appointed in her place, then you have to
yes,
you
Lordship.
have to array as respondent.
Yes, as per the instruction from the petitioner, till now, since from 2019, they have not arranged any body as addition to or substituting the petitioner, Lordship.
Yes. So we'll start.
Lordship. Now here
you are appearing for yes, miss.
Respondent number 5 and 6, Your Lordship.
Managing committee.
Yes, managing committee. Yes,
Mr. Vacharji, you are also. Yes, Mr. Sir, please.
Yes, Lordship.
My friend may continue, my lord. In the meantime, I'll just get the file, my lord.
Yes.
Here the petitioner was appointed as an assistant teacher on 28 September 2015, my lord.
Annexure?
Annexure 1, my lord. It is at page 15. Page 15 of the writ petition.
Yes.
Thereafter, my lord, there was a order from the managing committee, that is Annexure 2, whereby it says that MC members of Haripara school have decided to releasing you, means like here in this particular on 15 February 2019, Annexure 2, page 17. May I read the letter, Your Lordship?
Yes, releasing letter.
Yes, releasing letter. With reference to subject cited above, we the SMS, managing committee member of Harapara UP school, had decided to releasing you from the assistant teacher from our school with effect from 15 February 2019 due to contesting 19 Dolan Rabah Hajong Autonomous District Council on 21st January 2019. According to the higher secondary, we have concern that without resignation or without concern with the authority have no right to contest any type of election. So, based on the rules and regulation, here we releasing you from our school. Lordship, this is the main contention challenge. This is where I was released from the school. Now, based on this letter, Your Lordship, I will come to the Annexure 3. The Annexure 3, page 19.
Yes.
This is the letter from the district mission coordinator to the block mission coordinator. The letter speak, Lordship, that I will read it. Please find enclosed here with the petition dated 14 February 19 received from the president and headmaster of Harapara school managing school, complaining against the conduct of Srimati Florita the moment assistant teacher coordinator Harapara, which is self-explanatory. You are therefore requested to inquire into the matter and submit the detailed report to the office of the undersigned within a week's time. This is the instruction given on the basis of the complainant made by the managing committee. The district mission coordinator has written this letter. Now, my lord, thereafter, there is one order, lordship, that is, I would like to take you to the page number 22, annexure 5. This is a very important. It's annexure 5. Annexure 5, lordship might have got it. Yes. Just it. On thorough pursuit of the report of number so and so, dated so and so, submitted by the block mission coordinator Trikirkila BRC, it is observed that no proper permission or approval was sought for contesting MDC election in Assam by Srimati Florita Dimoman, which is against the rule of department. Thus, in view of the above, as desired by the committee for taking necessary action from this end, undersigned for preventing such practice in future by any employee, do hereby release Srimati Florita Dimoman from the post of cluster coordinator of Hirapara CRC, while allowing her to continue the service as assistant teacher of Hirapara school, with the strict warning to be more responsible henceforth. Now, my I will just go to the facts. Later, I will argue, my lord. This. Yes. Thereafter, my lord, there is another letter they have issued. Page, that is the. This is the same letter. It's a type copy only. Now I will come to the page 28, annexure 8, my lord.
Yes.
Here, this is another letter issued by district mission coordinator, where it says that I will just read it, the relevant part. With reference to subject stated above, I am to inform you that Sri Florita Moman was departmentally released from her service from the post of CRC based on your complaint and authorized contesting MDC election without any knowledge and permission from authorities, since she was departmentally appointed for CRC. Regarding the termination release from assistant teacher, it is duty of the SMC, since under SSA norms, SMC are empowered for teachers appointment. The said teacher was appointed by concerned SMC. The DMC approved the appointment done by the SMC to all SSA school. Therefore, you are hereby directed to issue a fresh order immediately to the assistant teacher whose service is unwanted to your school as your claim letter so and so, without sending any complaint to DMC office. The DMC already done its part. The copy of the action taken report should submit to the office of the undersigned without fail. Now, other letters are, these annexures are not important, because this is just a letter and a representation submitted by the petitioner saying that to consider, because he said that she has contested. However, she admitted she did not ask for permission, proper permission. That's the thing. Now, my argument here is, my lord, now the petitioner had been released. The main contention, he has been released from service. Now, my contention is this: while releasing the petitioner from service, there is no proper procedure has been taken from the as per the provision of law. They have not taken any provision relying to department that she should be terminated without disciplinary procedure, I should say, without disciplinary action. The petitioner was terminated from the service. It's amount to terminating because and secondly, while releasing the petitioner from service, no approval or confirmation was taken from the authority. And secondly, I am relying on the annexure 5, your lordship. Annexure 5 is very clearly where I would like to rely. I will make once more here. In the annexure 5, it says that issued by the district and account officer. The letter very clearly says that, I will just read it once again. On thorough pursuit of the report and so, the submitted by block mission coordinator, Trikikula BRC, it is observed that no proper permission or approval was sought for contesting MDC election as some vice committee so, which is against the rule of the department. Thus, in view of the above, as desired by the committee for taking necessary action from this end, the understand for preventing such practice in future by any employee do hereby release Srimati Florita D. Moman from the post of cluster coordinator of Hirapara CRC, while allowing her to continue the service as assistant teacher of Hirapara in UP school with strict warning to be more responsible henceforth. Now here my argument is because it is the fact that department also have known that he has gone for the election without the prior permission of the SMC. Therefore, as a punishment, Lordship, they have released this particular petitioner from the post of cluster. Otherwise, also, my lord, even this cluster also, there should have been any departmental proceedings should have been done, but without doing even that, without following the due procedure, she was even released from the post of cluster coordinator, and further saying that though she is released from the post of cluster coordinator, but she was still allowed to continue as an assistant teacher. So she was holding the two posts very clearly, and now illegally, without even following the due procedure, they have removed from the cluster, from the post of cluster as a post of cluster coordinator. And secondly, the most important thing is now she has been punished with the removal of the cluster coordinator, but the government have considered that she should be still allowed to continue as a assistant teacher. Now my point is, though illegally, without following due procedure, she has been removed from the cluster, from the post of cluster. That is the punishment, one punishment she got. Now again, this letter clearly says that she should be allowed to continue as a assistant teacher. Now interestingly, without issuing any termination letter, the managing committee was not allowing to continue in service without any termination giving or any termination officially giving the termination letter to the petitioner. Now to support my case, Your Lordship, I have before I have given this chart, I have given to everybody. There is a one which I have enclosed it, page number 1 of this this one. It is there. I have given to them also. This is the rule only that I will just. This is rule only. This is the rule of the Meghalaya Education Court only. This is nothing new. It is. I will just rely on the page 1 is there. Page 1. This is the section 9, para 2. I will just read it. Page number 1. Page number 1. This is given rule 9 section rule 9(2) is there 9 bracket 1 and 2. I will just read it 2.
Yes.
It says that subject to any rule that may be in this behalf, no employee of a recognized private school shall be dismissed, removed, or reduced in rank, nor shall his service be otherwise terminated except with the prior approval of the competent authority. Now this provision has not been followed. This is the law actually. Now what happened in this particular case? They have released me. They have terminated me from service, and the letter of they have informed, but there is no approval from the government. Government only says that we have accepted your letter of complaint against the petitioner. So on the basis of the complainant, the government have, of course, not as per the complainant, but they have not released or terminate the petitioner from assistant teacher, but as a punishment, I have been released from the post of cluster. So the matter ends there. The matter ends there. However, even the procedure, even due procedure which I have read it, the rule clause 2, even that also have not followed. So now petitioner is not against the remover of the cluster coordinator. She is not contesting. However, the letter otherwise is very clearly stated that I have given a punishment for the same. They have removed, and still saying that I should be allowed to continue as a assistant primary teacher. Even that also, there is no, as per the rule, your lordship, they should have issued me the show cause notice. Thereafter, I should be given an opportunity to file my show cause. Thereafter, if not satisfied, they can suspend me or they can go for the inquiry. After the inquiry, if there should be a finding, the inquiry, my statement should happen. I should be given an opportunity to defend my case. After, if not satisfied with the inquiry officer, they should be given a clear finding. Then only they can terminate. But still, as per the law, against the finding of that one, also I can still file and appeal the appropriate. That is the procedure actually. But here in this case, they have used the shortcut method, they have not at all follow any procedure. Why terminating? Because this is a government school, partly recognized SSS school, not purely, and they are expected to follow the procedures. While terminating and removing the petitioner from service, my lord, they have just issued one letter alleging that I have contested for the election and directly releasing me, and they have sent that letter to the authority, government authority. Government have taken action as per their complaint against me, and thereafter they have punished me by removing from cluster coordinator. Then after that, still they allow me to continue as a service. Now my contention is, for committing one crime or violating one, they have punished me with two things. It's like amounting to Article 22 or 21 is there should be double jeopardize for one. Actually, of course that is for mainly for criminal, but here also that principle can apply. I have been already punished. I'm not even contesting. Even the removing from cluster coordinator also was illegal. First, my contention is that they have not at all followed the rules. And secondly, the document, whatever document against me, like charges against me, till date they have not punished any charges against me, saying that I have not followed this one. Where is the allegation against me? Now, I will just come to the affidavit in opposition filed by my learned friend from the government. I will read it to your lordship. Now here they have admitted. I will take you to the affidavit filed by the state respondent, my lord. That is annexure 1. Annexure 1. 2. I will just.
Respondent 2 or respondent 5 and 6?
This is for respondent 1, 2, 4, 1 to 4. 1 to 4. State respondent. But they filed for respondent on behalf of respondent. I think it is for all the private for the government respondent. Then the private respondent advocate Sima is appearing. The annexure 1. Then I will come to annexure 2, my lord. I will just read it this letter. Page 10.
Just
With reference to subsection, I may inform you that
just a moment.
Lordship.
Yes, Annexure 1.
Annexure 1, page 10, my lord. It says, with reference to subsection, I am to inform you that the report submitted by SSA, TNB report dated so and so, with regards to inquiry into the complaint against CRC coordinator Hidapara by you. It is observed that you have not conducted an inquiry involving both parties, but has submitted only the reply submitted by the coordinator, making it difficult for the undersigned in understanding the matter in its entirety. You are therefore requested once again to inquire into the matter involving all the stakeholders and submit the detailed report to the office of the undersigned within a week's time, so as to enable the undersigned to initiate necessary action from this end. This letter otherwise speak, that means is admitting they have not done as per the rule. There was no proper inquiry against the petitioner. So they are saying that you should conduct an inquiry, proper inquiry, then submit a report to the undersigned, that is to the school education, that district mission, so that appropriate action as per the rule provided therein can be taken. Now, secondly, I will take it to the Annexure 2, that is the same this page.
See, Mr. Sangma, if I can understand correctly, 2 inquiries are supposed to be conducted by 2 authorities.
Lordship.
One is the SSA authority with regard to your post as CRC.
Lordship.
So that is, with regard to your post as CRC, the SSA authority or the government for the matter will have to conduct an inquiry.
Lordship.
Now, the other inquiry is supposed to be conducted by the managing committee as regard your position as assistant teacher.
Lordship.
So 2 inquiries are supposed to be conducted, which was not done so.
No doubt.
Now, this is with reference to the inquiry as far as the post of CRC is concerned.
Lordship.
But just a while ago, you said that as far as the petitioner is concerned, she has no objection, or she has no say as far as her termination as CRC is concerned.
Yes.
If that is the case, we need not go into all this.
Yes.
See, this will not come because you have accepted
yes.
the fact that she has been released
yes.
as CRC.
Yes.
So even if there's inquiry or no inquiry, makes no difference.
Doesn't matter. Yes, that matter.
Okay. So you go to the next part.
Yes, next para where there was a stated regarding the assistant teacher.
Yes, go to that part.
Yes. Now I will read the whole thing, because if I leave it, my another counsel may say that I only read some part and I left the part. So it's better that
as far as CRC is concerned.
Yes, I'm not contesting. They have removed it, so I accept it. I'm not contesting that. Yes, Lordship. Now the second letter, it says it speak about both the CRC, also this one, also assistant teacher. I will read it.
You're reading which part, no?
The last part is that page 12. Page 12, the same annexure. Page 12 only. This is the page 10.
This is another annexure.
Yes, another annexure is there.
This is annexure 2.
Annexure 2.
Page 11. You should have said.
Yes. The relevant.
Yes. Relevant portion is page.
Relevant portion is page 12 on the second para.
Yes.
May I read it, Lordship?
Yes.
On inquiry about procedure of releasing her from the post of assistant teacher, the undersigned have observed that SMC did not serve so-called notice or explanation call before issuing a release order to Srimati Florida at the moment. The undersigned also inquire the final decision of the SMC member and observe that there was mixed response. Yes. However, most of the SMC member decided not to take responsibility in their own hand, instead decided to hand over to the district mission coordinator to make the best decision in order to function the school smoothly. So this letter speaks otherwise, my lord. They are saying that since it's clear there is no inquiry on the alleging against the primary teacher, and then they said that there is no show cause notice. This is the department is admitting no show cause notice or no explanation call was issued to the petitioner by the managing committee prior to releasing the petitioner from as an assistant teacher. And it is later further says that the undersigned also inquired the final decision of SMC. There is no final decision, SMC member, and observed that there was a mixed response. However, SMC member decided not to take responsibility in their own hand, instead decided to hand over to the district mission coordinator to make the best decision in order to function the school soon. Now they are shifting the responsibility to the block mission coordinator. Otherwise, in the annexure 5, they said the letter clearly says that they are the managing committee is the appointing authority. It is their duty to take action against the petitioner. They can take the action against the petitioner as per the law, but on the contrary, they should take the action as per the law and then provided the decision taking the approval from the competent authority, then the as follows. But here in the contrary, now the letter is saying that you have not taken action against the petitioner, neither you have issued a show cause notice, nor you have for any explanation call. Now they're shifting the responsibility. They're saying that no, it is mixed. It is not our duty. Let the district coordinator or authority take the decision. Otherwise, it speaks against the law, because the law says that very clearly says the appointing authority is the SMC. Appointing authority should take an action, but now they are saying that we will not take action. Government says that it is your duty to take action. It is you have appointed. We just approve. Now you have to take action as per the law. Now in this letter, there is very clear saying that neither they wanted to take the action against the petitioner, but they have released without following due procedure. It is clear, it is on record. They are saying that they have neither issue, not even a show cause notice, not even an explanation call. Now on top of that, they are saying that now you have not done anything. Now you are saying that all the action should be taken by the district coordinator. How can the district coordinator, the government can take an action because they are not a appointing authority? That is law. If they are, that's why they are saying that since we are not appointing authority, we cannot take action. So you have to take it. Now they are saying you have to take. So this is a clear, and in the letter is clearly there is no no law procedure has been followed. In this lordship, now I will not. I will just sum up my this one there regarding the non-supply the conduct of inquiry. There is another order of the High Court also have passed an order. This is the order. I think on the last occasion also provided, Lordship, it is the part of this order only, but just for reference, it will be on record also. In the order dated 0-5-2023.
Same case.
Same case only, but there was an order from this court. From this court means it was the bench saying that the directing the government to produce this one. May I just read it, Your Lordship? By the order of 28, this court has directed the learned GA to produce the record of inquiry stated to have been conducted by the block mission coordinator SSC West Garo Hills on 13/4/2023 when matter was listed. J did not produce the record as there was change of inquiry set office as As such, 2 weeks' time was granted by this court to produce the said record. Today, Mr. Miki Patasaji, learned contribution state respondent, submitted that he has received some instruction, but do not seems to appear to be the record as called by this court. This court not its disapproval in this in the conduct of the said mission coordinator. However, in the interest of justice, another opportunity is granted to produce a relevant record on the next date, failing which the concerned officials shall appear personally before the court. Now, my lord, here we are not insisting for appearance of the officer, but the letter says that the detailed inquiry report. However, till now the government have not able to produce. That means this clearly says that there is no inquiry.
See, now again, see, as far as the inquiry is concerned,
Lordship.
see, by the block coordinator,
Lordship.
it is only with regard to your post as CRC
Lordship.
cluster. Huh?
Lordship.
So that has, that we have decided.
Not, I'm not. Yes, I'm not.
Only if action has been taken or initiated
Yes.
by the managing committee, then.
Now there is a. I will just I will sum up that with last this one. There is a decision. I think that this order also will be covered by this judgment passed by the division bench, where my lord also is the part of that bench only, because there in the case of I will also like to take it to the compilation I have enclosed the judgment, page 71. Page 71, where my lord passed an order, because this is the very similar matter. Instead of reading the entire record, I will just would like to place the relevant operative part, which I feel that is very important, Lordship.
Yes.
I will just read it to the page 73. The otherwise judgment started from page 71. This is judgment from passed by your Lordship only.
Yes.
This is WPC number 379 of 2017. The order dated 20/06/2022.
Yes.
I'll just rely the para 8, because others are that's the same story here also.
Yes.
Para 8. The another limb of the argument advanced by the petitioner is that the impugned order was passed in complete violation of the petitioner's right in as much as no explanation was called from the petitioner, no prior show cause notice was issued to him, and no inquiry was also conducted against him to enable him to answer to the charges made as indicated in the impugned order. Even otherwise, now para 9. Even otherwise, the school of the petitioner being recognized private school, the provision of Meghalaya School Education Act 1981 is applicable, and subsection 2 of the section 9, which I have read out earlier, this is my lord also have quoted the same, of the said act, provided that subject to any rule that may be in this behalf, no employee of recognized private schools shall be dismissed, removed, or reduced in rank, nor shall his service be otherwise terminated, except with a prior approval of the competent authority. And this provision has been violated in as much as the prior approval of the competent authority, who is the joint district mission coordinator, Tadengri, has not been obtained by school authority before termination of service of the petitioner. So this is the very clear, Lordship. Now I'll go to the 15, para 15, same judgment. It is same continuation of that one only. It is page 76, my lord.
Yes.
The contention of the respondent 7 to 9 as regards the eligibility to hold the post of administration, the said school cannot look into any by this court at this juncture, since the main issue involved as to the legality or illegality of the said impugned order the same having been found to have been issued undue procedure and in violation of natural justice, principle of natural justice, this issue does not merit on contention. No, here it says that the basic principle of natural justice has not been followed. So that is another judgment. Then in the there is another page 70 is also is a judgment only. This is a division bench judgment, Lordship. Page 78. It starts from page 78. This is a judgment. I think even my lord also was part of the bench. This is the order. Yes, in MCWA.
I think this will not be relevant.
It is relevant, but yes, Lordship.
Because we have not reached that stage.
Yes. So your Lordship, I will wind up my submission that since only thing I don't want to repeat, since no proper procedure have been followed, the rule 9(2) of the Meghalaya Court Education have not been followed. So that is the only thing. And then there is two punishment I have already. They have punished me by removing the cluster content which I am contesting. Still allowing, but still this one. Then absolutely. And from the record it says that whatever maybe that I have done, that proper procedure have not been followed. None of the document like charge it against article of charge, and nothing has been done against me. That is my only humble submission before this honorable court, your Lordship.
Yes.
Much obliged, Your Lordship.
I think managing committee should answer first. Yes. Let's see. Yes.
Your Lordship, may you please to take out the affidavit in opposition, Your Lordship, filed on 7/11/2023 by the respondent number 5 and 6, precedents.
Yes.
Your Lordship, here Secretary has filed this affidavit on behalf of the President also.
Yeah.
So, Your Lordship, it is a fact that the petitioner is in a was a government teacher, SSA UP school, and appointed on 28 September 2015, Your Lordship. And thereafter, Your Lordship, petitioner participated in the MDC election of Rabha Hajong Autonomous Council on 21/1/2019, Your Lordship, without seeking permission of the higher authority of the Education Department, Your Lordship. In that event, Your Lordship, your petitioner neither sought the permission of the school authority nor the higher authority competent, that is distribution coordinator or director of the Education Department. Thereafter, Your Lordship, petitioner has alleged that petition was served with a release order. This release order, what my learned friend is mentioning, is 15/2/2019. It is a release order from the post of cluster coordinator, Your Lordship. It is not that the final termination order. Thereafter, Your Lordship, the petitioner, the school managing committee has issued 2 termination order, Your Lordship. No, Your Lordship, may I please, Your Lordship, issued 2 notices. Show cause notice to come and appear to discuss about the MDC election, Your Lordship. Your Lordship may kindly come to page number 11, Your Lordship, annexure 2 of my affidavit. This is a Garo notice, Your Lordship, in Garo language. Next page is the translated copy in English, Your Lordship, page 12.
Yes.
Yes, Your Lordship. Your Lordship, kindly take the note of the date, Your Lordship, 8 February 2019.
This is notice.
Notice, Your Lordship. I have annexed with the Office of the Hirapada SSA UP School, West Garo Hills, Meghalaya, Your Lordship, dated 8 February 2019. Notice for the meeting, Your Lordship. Headline. To Mrs. Florita, may I, Your Lordship?
Yes, yes.
To Mrs. Florita de Momin, with regards to your contest in the MDC election, you are requested to come and discuss with the SMC, School Managing Committee of Hirabada School, dated 11/2/19, Your Lordship, at 10:30 AM, Your Lordship. It is issued by the headmaster, Hirabada School, Your Lordship. Next, Your Lordship, Annexure 3, another notice, Your Lordship. This is also in Garos, and I may take Your Lordship to page number 14, which is a translated copy in English, Your Lordship. Your Lordship, kindly note the date, 12 February 2019.
Yes.
So here also same contents, Your Lordship. To Mrs. Florita de Momin, with regards to your contest in the MDC election, you are requested to come and discuss with the SMC, School Managing Committee of Hirapada School, dated 14/2/2019 at 10:30 AM. Despite issuance of 2 notices, Your Lordship, petitioner neither approached the school authority nor sent her representative, anyone. So this allegation is the allegation that no procedure was followed before issuance of termination order, and whatever petitioner has annexed with the petition, and in the prayer part of this petition, Your Lordship, 15/2/2019, this is not the termination letter, Your Lordship, issued by the school authority. It is from the this letter was issued only for annexure 2, annexure 2, page 17 of the writ petition, Your Lordship. It is only for releasing from the cluster coordinator, Your Lordship. It is not that the petitioner has been terminated from the post of assistant teacher of the SSS school, Your Lordship. And in the prayer portion also, Your Lordship.
See, you read that letter.
Yes, sir.
15 February.
With reference to the subject cited above, with the SMC members of Hirabada SSS school has decided to releasing you from assistant teacher from our school with effect from 15 February 2019.
Yes,
Yes, Your Lordship, for contesting election in the MDC election.
Exactly.
But Your Lordship, this releasing order is neither it is not approved by the authority, competent authority, nor petitioner was asked to leave the school.
Exactly. So that is the contention of the petitioner. Also,
Petitioner, yes,
that
yes.
this letter was issued without following procedure. So you have also agreed to that.
Yes, this letter
that
was
this
issued,
letter
but
was,
thereafter, Your Lordship, you see, these 2 notices were already there.
that is fine.
2 notices were there.
So you see, now in effect, the petitioner has not yet been or has never been terminated.
Thereafter, Your Lordship, my assumption is that yes.
Right. After 15 February, what happened?
After 15 February, Your Lordship, in the meantime, Your Lordship, there is a prayer for paying the salary. So, in paragraph 13 of my affidavit in opposition, Your Lordship, petitioner was paid the amount. So, this allegation or grievance of the petitioner is resolved, addressed by the school manager. It is on record, Your Lordship.
Just to clarify, my lord, only.
Just a moment.
Yes.
You can clarify.
Yes. Yes.
Because you have not raised that issue of salary.
No. We already got it after filing of the repetition, Lordship.
Whatever the case.
That is no more issue, Lordship. Yes.
So that is not an issue.
Lordship.
So, first part of the prayer of the petitioner is addressed. So, it is on record, Your Lordship. Annexure 4 and 5. 5 is the of this annexure 4. 4 is the page 15, Your Lordship.
Yes.
Banks 2,15,217. 2,15,177. Your Lordship, already paid to the petitioner.
All these area salaries.
It is not extra amount which was deducted from the salary of the petitioner.
This petition has no issue with that.
Yes. So it is paid and it is on record also. It is noted by the Honorable Court in Annexure 5 also, Your Lordship. So this thing has gone, Your Lordship. It is not required. Thereafter, Your Lordship, Annexure 6 is the termination order. 25/01/20.
Yes.
This is the termination order. Page 17. Yes, Your Lordship.
Yes, yes.
Termination letter dated 25th January 2020. This is the termination letter, Your Lordship. But petitioner has not annexed this termination letter with the writ petition. Petition was filed in 2021, Your Lordship. And petition, not only that, Your Lordship, while
I reply, Lordship.
Yes.
while inquiry was conducted by the government authority, it is that petitioner also participated in the inquiry. It is not that petitioner did not know anything about the inquiry. It was admitted that her father has sought the signature of the principal in a blank paper, Your Lordship. Your Lordship, kindly have a look at the annexure 2 of the annexure 2, page 11 of the affidavit in opposition filed by the state government, Your Lordship. My learned friend has read the just last page, Your Lordship, not the whole contents of this inquiry, Your Lordship.
Annexure 2.
Annexure 2. Your Lordship may kindly look at the date 8/8/19.
Yes.
It is not that the procedure, neither the government nor the school authority has followed the procedure. It is the inquiry conducted by the distribution coordinator. Your Lordship, may I read the whole thing? Yes,
please.
Your Lordship. Distribution coordinator SSA, inquiry report on complaint against Hirapada CRC coordinator regarding, Madam, with reference to the subject cited above, I have the honor to submit the inquiry report on complaint against Srimati Florita D. Momin, assistant teacher cum CRC, coordinator of Hirapada SSA UP school by the SMC of Hirapada SSA UP school regarding the contesting at 19 Dadan Raba Hajong Autonomous District Council as an independent candidate, which was held on 21st January 2019 without proper permission of the SMC of the above mentioned school, Your Lordship. Madam, the inquiry was conducted on 25th July 2019 at Hirapada SSA UP school itself by the undersigned with the BRP, Sri P. Narjari and Sri B.M. Sangma and me. MIS coordinator Sri Rajiv Barman. During the time of our inquiry, all the SMC members were present. That, Madam, during the inquiry, the assistant teacher cum CRC coordinator Srimati Florita D. Momin gave her statement that she had contested at 19 Dadan Raba Hajong Autonomous Council as an independent candidate, which was held on 21st January 2019. She also told that she informed the headmaster through her father as she was unable to come and meet the headmaster as well as the SMC members. So it is not that she is not aware of the inquiry conducted by the officials, Your Lordship. Thereafter, Your Lordship, it was also stated by the headmaster of the above mentioned school that her father took signature from the headmaster.
Headmaster, head teacher.
Head teacher of the Hirapada SSS school, Sri Sengnan Momin, given his signature with seal on the blank sheet of the paper without knowledge of other SMC members, Your Lordship. When inquired about the same, Florita D. Momin, assistant teacher cum CRC coordinator of Hirapada SSA UP school, unable to produce it, stating that it was misplaced somewhere at home, Your Lordship. So it is not that she is not aware of all these things. Before final termination was issued to her on 25th January 2022, inquiry was conducted on 8th August 2019, Your Lordship. So petitioner could have annexed this termination order, Your Lordship. Thereafter also, when the government advocate filed this affidavit in opposition in last July 2023, petitioner could have withdrawn and file fresh writ petition seeking praying for setting aside the termination order. So petitioner, this writ petition is not maintainable in this, Your Lordship, because correct termination order is not annexed with the writ petition, Your Lordship. Thereafter, Your Lordship, this before termination order, there was a resolution taken on Annexure 8, Your Lordship. Before the page 20 of my affidavit in opposition, Annexure 8, Your Lordship. Your Lordship may kindly look at date 25th January 2020. This is Annexure 8, page 20 of my affidavit in opposition, Your Lordship.
Date 25.
Date 25th, second line, Your Lordship, 25th January 20.
Yes.
So this resolution was taken for her termination, Your Lordship. And it was forwarded also, Your Lordship. It was forwarded at page 22, annexation 9, Your Lordship. Forwarded to the competent authority, that is District Mission Coordinator, by letter dated 11th August 2020.
Yes.
May I please, Your Lordship?
Yes, sir.
Your Lordship, annexure 7, page 19, Your Lordship.
Yes. Please read.
Yes, Your Lordship. Resolution dated 25 January 2020 and appointment of teacher in the vacant post, Your Lordship.
Yes.
With reference to the subject cited above, I am to inform you that the resolution dated 25th January 2020 terminating the post of Srimati Florita D. Momin, assistant teacher of a school with effect from 25th January 2020 is hereby accepted, Your Lordship.
Okay.
So, Your Lordship, it is not, and not only that, Your Lordship, petitioner should have, before contesting election, petitioner have sought the permission of the proper authority, either the SMC or the District Mission Coordinator, for permitting her to contest. Petitioner did not do that, Your Lordship. So, my humble submission is that all the rules were followed before issuance of termination letter, Your Lordship. Number 1. Number 2, Your Lordship, 2 notices were issued. Petitioner never approached the school authority or through either through letter or by anything else. Never. Third is that, Your Lordship, petitioner participated in the inquiry conducted by the government authority in the school. She herself was present in the school, so she is aware of all these things, Your Lordship. So she did not come forward, just file this writ petition with an annexure which is not a termination order. So this is there is no merit in this case, Your Lordship, that Your Lordship may decide the issue whether set asiding the order or petitioner may be reappointed. So my humble submission is that, Your Lordship, this writ petition is not maintainable because proper termination order was not annexed to the writ petition, Your Lordship, and all the rules were followed before terminating the petition, Your Lordship. And even higher authority as school District Mission Coordinator also accepted the termination letter which was forwarded to them, Your Lordship.
Just
Yes, Mr. Let him finish. Let him take. Yes.
I have a very short submission, my lord. My lord, the first instance, my lord, this writ petition, in my humble and respectful submission, my lord, is infructuous. My lord, the petitioner is relying on events, my lord, that have occurred in the past. What ultimately culminated, my lord, and where the termination order is issued, my lord, that is not under challenge, which is subsequently approved by the District Mission Coordinator. That is not under challenge at all, my lord, before this honorable court. Petitioner has based her whole case on some past event, my lord, and that what the petitioner is relying on is not a conclusion, my lord.
Yes.
Things have proceeded thereafter, and then ultimately termination order was issued. My lord, my friend is relying on the report. My lord, that report is of the year, my lord, where it is stated that it was not satisfactory is 25/6/2019.
Where they stated that no proper inquiry was
My lord,
conducted.
subsequently another inquiry was conducted, which is dated, report file dated 8/8/2019. So like, these are all past events. Now what happened thereafter, my lord? My lord, thereafter complaints, some more complaints were filed by the managing committee, that is dated 25th November 2019. Subsequently, my lord, there was a termination order which was issued on 25/1/2020. That is not under challenge before this honorable court. My lord, assuming this honorable court grants the petitioner a relief, my lord. But my lord, the termination is still in place, my lord. That cannot be set aside because it is not there in the prayer of the writ petition, my lord. The correct stand of the writ petition would be, my lord, I should not be suggesting, but my lord, they ought to have filed a new writ petition challenging the termination order, my lord. Because these events which the petitioner is thoroughly relying on is all past event. This, with the passing of the termination order, all the past actions have become redundant. There is no value in the eye of law, my lord. Secondly, the petitioner has been stating placing reliance on the Meghalaya School Education Act. My lord, as I have earlier submitted in other cases as well, my lord, this is an SSA school. So, my lord, my stand would still remain that the rules that will be applicable will be the, my lord, will be the RT rules and the RT Act 2009, my lord, not the Meghalaya School Education Act. Now, my lord will kindly see the representations of the petitioner also. My lord, the representations which are at what are the representations which are at my lord, page 34, 35, 36, 38, my lord.
Page 30
My lord, 34
of what? Of the
34 of the writ petition.
petition.
My lord, here the primary complaint of the petitioner is release of salary, my lord.
But this issue has been dealt with.
Yes. So, my lord, the letter, the representations addressed to the government is what, my lord? Because the petitioner is stating the government has not taken any action. What is the representation? Only release of salary, my lord.
Yes.
My lord will kindly see the next representation also.
Page.
My lord, at page 36, typed copy.
Yes.
My lord, this is also release of salary. However, my lord, whether the petitioner is having knowledge of termination, etc., my lord will kindly see if I am allowed to read, my lord. With reference to the subject cited above, I have the honor to state that your esteemed office have informed me with regards to the direction to release order placed it to the concerned school managing committee to release all the pending due salaries based on the order and informed action given by your esteemed office. I have approached the concerned school managing committee and requested to release all pending salaries, but surprisingly the school managing committee has asked me to pay some amount out of my pending salary on the ground that they have spent some expenditure from traveling from various schools, etc., etc. Therefore, SMC has refused to pay pending salaries on the ground that I disagree with the proposal of the school managing committee. Direction, therefore, in view of the above facts and circumstances, I request your good self to issue direction to Counsel School Managing Committee to release all the pending salaries that are legally entitled to me and issue an order to the School Managing Committee to pay all the dues without deduction through my individual bank account. So, my lord, the prayer is primarily salary, no other prayer, my lord.
Yes.
And my lord, thereafter, my lord, all this is in 2019, my lord.
Yes.
Now, my lord, if I take my lord through the annexures, my lord, which is at page 4 of my affidavit in opposition, my lord, page 15. My lord, this is the resolution, termination letter.
Annexure 3.
Annexure 4, my lord, page 15 of the affidavit in opposition filed by the state, my lord. That is, my lord, respondent number 2 filed on behalf of.
Yes.
It says, I do hereby inform you that the school management committee, Hirapara SSA UP school have been terminated due from being a teacher of assistant teacher with effect from 25/1/2020 due to your performance found unsatisfied to the SMC. The SMC have done as per order so and so, which order has been empowered to the SMC for termination and appointment of teacher. I therefore, on behalf of SMC SSA UP school, would like to request you to kindly not attend your school duty from the date of issue of termination letter. This is the letter which is issued, my lord. This was also forwarded to the district mission coordinator, which is at page 5, my lord. Apologies, my lord, page 16, annexure 5. So here, my lord, the decision is communicated. And my lord, thereafter, my lord, the extract copy of the meeting is at page 17.
Yes. That has been referred to by managing committee.
Yes, my lord. So this was the decision, and then it was forwarded, and then thereafter, my lord, the resolution was accepted by the district mission coordinator, and termination order which was served was issued, which was issued by the school managing committee, was accepted, my lord. That is at annexure 6, page 18, my lord.
Yes, annexure 6.
Annexure 6, my lord. What the letter says, my lord. With reference to the subject cited above, I am to inform you that the resolution dated 25/1/2020 terminating the post of Srimati Floritha D. Momin, assistant teacher of your school, with effect from 25/1/2020 is hereby accepted. And thereafter, there is also a direction that you kindly clear all the pending dues. So, Lord, that the private respondent has already admitted that all the pending dues has been cleared. Now, my lord, my respectful submission before this honorable court, my lord, what remains to be adjudicated in this before this honorable court, my lord? Because there is no challenge to the subsequent developments, and it is not a case that you have filed your writ petition and then subsequently some development has taken place. That is not the case. You filed a case in 21. Order of termination is issued way before you filed the case. You should have approached this honorable court with clean hands. You should have brought in all the records. You should have challenged the termination. But that you have not done. You have taken a plea that I have not been issued show cause notice and I have been illegally released. Now, the private respondent counsel has already, my lord, clarified before this honorable court, my lord, that the release order is with regard to the my lord, the
CRC
cluster coordinator. Now, even assuming that there is some defect in the release order, my lord, but that has already been overshadowed by the subsequent development, my lord, because all that is past. I'll have to rely on what is the current status. The current status is the termination letter. The current status is the acceptance of the termination letter. That is not under challenge before this honorable court. So, sum and substance, my lord, this whole petition is redundant, infructuous, there is no relief may be granted by this honorable court, my lord. Salary, pending salaries, that also has been cleared by the managing committee. So nothing remains in the case, my lord. The cases which my friend is relying on is of no relevance in this instant case. And it is evident from the record, my lord. So that is my humble and respectful submission, my lord.
Please, Lordship, I just have to reply some more point where my learned friends have submitted, Your Lordship. Firstly, I will take you to the same point where the board of the council are mainly relying on the release order. The release order where I was released from the assistant teacher. That happened on the 15th February 2019. The release order is on 15th February 2019 by the managing committee. It means like I'm released from the assistant teacher. What it reflects, what is the meaning and what's the content of that word? As per the various dictionary and others, otherwise it's contradicting. First, there should be a termination, then only release. Release as per the office order is that end of the matter. Termination is just the contract or anything can be just terminate. That is not the end. But how it will end, subsequently followed by the release order. Here it is opposite. They have released me. Now my learned friend, let him explain. First, they said that I have been released from service on 15 February 2019. Whereby on the basis of the release order, they have not allowed the petitioner to continue in service. They have not even allowed me to enter the school premises. That they are saying that they are admitting since from the day they have released me from the service. They have neither allowed me to even allowed to enter the school premises. That they are saying that you are no more the part of the teacher. What is the distinguish? Now they have to explain to the court what is the difference between the release order and the termination. Whether that meaning have different meaning or is otherwise. Otherwise, according to not my understanding, we go by the various notification and the rules and the definition of the dictionary. It clearly says termination is not the end of contract. It will end subsequently by releasing. Termination. But here, it is just the opposite. They have released me from service without terminating. That is the main point, Lordship. And my learned friend is saying that otherwise, what are the ordinary cases? How the government service or employer they will try or they will take an action. First, it should have been suspension. If there is allegation against me, they will file a show cause, issue no show cause notice to me. After issuing the show cause notice, I will file a reply. If my show cause or explanation code is not at all satisfactory, what they are going to do? They are supposed to suspend me from the service for time being, for the purpose of for fair inquiry. So here there is no suspension. Without termination, they have released, which is becoming ulta. Now, secondly, so that is the position. They are laughing at them. Let them explain then. What is the difference between the termination and the release? What the meaning here is? Let them tell the court now.
Mr. Sangma, whatever the case may be, if you are on the point of that release order.
Yes.
Well, it has not been explained in many words.
Yes.
But the council would say that that release is only from the post of cluster coordinator.
No.
Not that is debatable. The court will look into that.
Yes.
But now you have to explain the subsequent event.
Yes.
After, even if the release is taken into action or not, or was affected or not, that is beside the point.
Yes.
Because subsequently, notice was issued to you. You have even attended the inquiry proceedings.
No, I'm going to deny. Yes,
so
Lordship.
You reply on that.
Yes. Now, Lordship, they say that it is not the district managing committee who have released from the cluster coordinator. It is a district mission committee who has released me from the district that from the cluster coordinator. Otherwise, the letter dated 15 February 2019, issued by the managing committee, they have clearly stated, it is there on admission, it is on record, they cannot manipulate, it is there. They said that you have released, we are releasing you from assistant teacher, not from the cluster teacher. That matter. Now, secondly, my learned friend from the appearing on behalf of the managing committee have replied to her annexure. I will not repeat, I will just say annexure dated annexure 2 and annexure 2. Yes, there one letter is there. Annexure 2 and annexure 3. Here, my lord, first, number 1. See the letter. Here there are two dates. My lord. They stated that.
Annexure 2 and 3 of managing committee.
Yes, page 12 of the affidavit filed by the managing committee. Affidavit filed by the managing committee, private respondent, page 12.
Yes.
Here, my lord, I just read it. The office of the Hirapara SSS UP School, West Garo Hills, Meghalaya. Lordship may kindly note it, the date Hirapara 8 February 2019 is there. Subject notice for meeting. Then to Florida so and so. I'm not going to read the letter, but on last, the behind you will see another date. 11 February 2019. Firstly, I don't know what type of letter. How can there in one letter? How can there be there can be a two separate date? And secondly, let her reply after I reply all this, because now should not disturb. I don't disturb her. Now there is in one letter there are two letters.
See this date 11/2/19.
Yes.
This is the date where you are supposed to meet them. That is what is is indicated.
Yes.
It's how we understand it. Yes. But you did not go on this date.
Yes, but they don't. This is not a date. That is not mean, because here it is written in Garo. They said that J Chomotan Nangni UAPC Ubusta Sensini Vidingo Jaborni Singa River Pulchina Molmolinga. They don't mention any date in the Aspada because the translation. Otherwise, it speaks. Does not say that it should come on. It should come on. Here is the.
No, see, I think in the original. See, first the date, the timing came 10:30, then Tariq.
Yes.
11.
Yes. Okay. Now I'm not. Now secondly, my objection. Now okay, I will not. Now secondly, this sort of letter. Now let the managing committee prove and establish before this court that I have received this letter. In what way they have served this copy? How can they say that I have received this notice? This is very important, which I'm arguing. This is the which I insist the court to be noted, because I have never received this letter. It is only on the time when the private respondent have filed this affidavit in opposition after 6 or 7, after 1 year, I have received this letter. And now they're saying that they have issued this notice. They have also to prove me whether that letter has reached to me, whether I have received this notice officially.
Have you filed any rejoinder to this affidavit?
I think yes. I think I have filed it. I have filed it in my rejoinder affidavit. I have clearly stated that I have never received those letters.
Where is your?
Yes, Lordship, it is there in my rejoinder. Yes. I have filed my rejoinder.
On 7 February, December.
Yes. All those I have mentioned. In the letter dated so and so block mission community, or I have mentioned all this in my this one.
Yes, please show.
Yes. Document proof with a signature. See, in that para 3 also I have mentioned. The page 3. Page 3. The page 3 of my rejoinder, para 3. That column 1 to 3 I have mentioned.
Yes.
There is no document to prove with a signature of the petitioner on the copy of the receipt, copy to show that petitioner has received the alleged notice dated 12/02/2019 and 14/02/2019. All those things I have mentioned. In my reply, I have mentioned point by point. All those. Now they are saying that another point, my friend is saying that termination letter. Same answer I have given in my rejoinder that the termination letter were never punished. This order, if it is the case of the petitioner that I have received those termination letter, I could have my pleading order could have come up, then I could have challenged that this one. But I am saying that this termination letter, show cause notice, what they allege, have been never punished. They are claiming that if I have received, then I am relying on that para 3 which they have to show me that I have received those letters. But I am saying, even in my rejoinder and in my submission, saying that I have never received all those documents. That's why I have not said.
Where is your rejoinder to that effect?
Yes, Lordship, I have mentioned there.
That you have not received the termination.
Yes. That also I have mentioned.
6.
Yes, Lordship. 19. During the inquiry conducted, yes, it is there. The 6 paras 6. Managing committee that is from the service of the assistant teacher 15 so and so by the repetition. But alleged termination order, my lord, dated 25/01/2020 issued by the managing committee was never supplied and furnished to the petitioner till death. Therefore, due to non-supply of the
reading which
page 5, my lord.
5.
Page 5. It is Lordship have rightly point out. It is on point number 7. Point number 7. I have clearly mentioned. Point number 7. I have stated clearly. May I read, Your Lordship?
Yes, please.
The managing committee, that is the respondent number 5 and 6, have released the petitioner from her service as assistant teacher with effect from 15 February 2019, and the said release order dated 15/02/2019 is under challenge by the instant writ petition. But the alleged termination order dated 25/01/2020 issued by the managing committee was never supplied and furnished to the petitioner till death. Therefore, due to non-supply of the document, that is the termination order, petitioner was not unable to challenge against the termination order dated so and so. It is stated that the petitioner strongly deny the receiving of alleged termination order dated so and so, and the said alleged termination letter was enclosed by the state respondent only after 1 year when they filed an affidavit in opposition in respect of the petition filed by the petitioner, and hence no procedure had been followed by the respondent authorities while terminating and releasing the petitioner from her service as an assistant teacher from Hirapara SSA UP school. I have mentioned, Lordship. So there is not much to say. That only that is my only submission, Your Lordship.
Yes.
So that is my end of my submission, and the other things are not relevant, my lord. So that is my humble submission before this court, Your Lordship.
I think you have to prove those things, whether even if the notice, show cause notice has been received, since you say that eventually she has participated in the inquiry, though she was not present, but her father had gone there. Even then, now your termination order is said to have not been received by the.
But Your Lordship, last year affidavit was filed by the government advocate in July 23. This almost 7 months gone, and petitioner has filed the rejoinder in December 23. So during 6 months, petitioner could have withdrawn and filed a proper petition, Your Lordship, challenging the termination order.
No, no, that is a different
That is
thing.
not the law.
Fact remains. The termination order is not under challenge. That fact remains.
Yes, because it was not received by him,
My
by
lord,
the petitioner.
My lord will kindly see what is the RTI filed by the petitioner.
No, we
There
have
is no
not filed the
whisper.
RTI.
Yes, petitioner has filed an RTI, but there is no whisper about that. My lord, if the release order is issued in the year,
That is in February 2019.
Yes. Even on the inquiry, they say that I have.
15th February 2019. Writ petition is filed in 2021, my lord. What prevented the petitioner from challenging this release order then and there?
Hey, that's beside that's beside the point. That aspect will be looked into.
My lord, assuming my humble and respectful submission, let's assume that everything that is done by the managing committee and the government is wrong. Let's assume that situation, my lord. My lord, even then, my lord, in my respectful submission, my lord, no relief can be sought from this honorable court in absence of, my lord, non-inclusion of your prayer does not include the termination order. My lord, you are hitting something which is already dead. That is a dead cause, dead case, my lord. What is fresh is the termination order. Now, a dead horse cannot be brought back alive, my lord.
See, Mr. Sama, I think what Mr. Bhattacharya said is correct. Now, when the counter affidavit was filed, the order of termination was annexed. You have filed rejoinder of file. But it has come to your knowledge at that point of time.
Yes.
You should have amend your prayer and challenge the termination order. Also indicating that you have not received copy of the same.
No.
You have not done that.
Only thing is that now they have to distinguish what is the between the release order and termination. It's the same.
That is beside the point. The point is now we are talking pointedly to the termination order, which was received by you or came to your knowledge in course of these proceedings. We are talking about the sum and substance and nature of this petition, instant petition. Had you made a prayer to amend your, file a petition to amend your prayer, that would have been.
Lordship, I will just, if that is the case, otherwise, my lord, I have categorically stated that because non-supply of the document, that is very bad. Why should they should do all this behind my back? All these things behind my back. Otherwise, I have stated if that is the case that you have received back, because otherwise it will be a time consuming, unnecessary, because if they have never supplied this document.
But if that is so, my lord, the
So,
petitioner
see,
could have
what you can do now, you can
I will amend
you can cite authorities or case laws which will be in your favor to say that in spite of having received notice or other information about the termination order in course of these proceedings, you are not required to amend your prayer. Number one.
Lordship.
Number two is that since you have maintained that you were not informed of the termination order, so you are not liable to challenge it. Those are the two facts that you can prove to this court by way of relevant authorities. Similarly, they will also have to prove their case that it is not necessary to distinguish between releasing and termination in view of the subsequent events which have transpired.
My lord is correct.
So that would be your stand, and that would also be your stand. So as far as this matter is concerned, you file your.
Lordship, I will humbly pray before this honorable court. I may be just allowed to amend my prayer portion.
Question of amendment at this stage does not arise.
Because at any stage I can, because the rejoinder I filed it on behalf of because after 2 years only the private respondent have filed that also after during the course of hearing, the court have asked why you have not filed. Then only, let me just complete my submission. When they, I'm not talking about the state respondent of filing the delay. I am not. They have filed it on time, but at the time of argument only, private respondent have sought for filing the affidavit. Then only it is on record. It is not on order only. When the court has intervened for not filing the affidavit, then only they said that we will file it. The court have allowed them. When the court have allowed up to 3 years only, they filed it affidavit and bringing on record all the termination, everything. Now, if that is the case, why we have this court has been, this matter has been since from 2019. Now it is at the time of hearing. Again, that filing of amending the prayer, it will not take much time. We can within 2-3 days, can within 1 day also I can make an, because Lordship has already indicated the clear position of law where I stand. Of course, that is because my learned friend has submitted, maybe considering that they have not followed the procedure, everything, because he said the main things, of course, I am not denying, of course, that is correct, but otherwise also, that termination is not actually not required. But one only thing is that the legal implication is that since 2025 on the February, that termination has been filed. That's why I'm saying that, yes.
If you had attacked the issuance of the termination order, you could simultaneously also make your contention that due procedure was not followed. So in that, in that respect, the court would look into all this aspect. But then, since, as Mr. Bhattacharjee has submitted, since the termination order has not been challenged by you, there is no pleading. There may be a rejoinder. There's no pleading.
Yes.
So what do we do?
I will, Your Lordship, I will amend those, I will just amend those petition, including the challenging the order of determination.
Your Lordship, to submit your Lordship permit me. Earlier, Your Lordship, there is a mistake in the cause title. Then Your Lordship was pleased to allow the petitioner to amend the cause title. Now petitioner has come up with the prayer part that it may be, he may be allowed to. So Your Lordship, I give you.
No,
I have
there.
And what is beyond pleading?
Mr. Sangma, what I'll do, as of today, we will leave the matter as it is.
Lordship.
I'll give you a chance.
Lordship.
On the next day, you come with relevant authorities and relevant case laws to support your contention that you can amend the prayer even at this stage.
Lordship.
When everything is said and done. Hearing has already concluded.
Yes, Lordship. Lordship.
But if you can convince this court that even then, this court can allow, I will do it. Otherwise, their case, their contention will stand. You come next date.
Lordship.
And we'll come.
So many times agreement was sought and we have
No, this is not because
this
cannot make this argument
of judicial review where justice is to be imparted to all.
Yes.
Complete justice. Justice has to be seen to be done, not only done. We'll do that, but only on that point.
Lordship.
You may have
relevant
authorities. You may also have authorities which will be against that.
Yes,
Lordship. Issue of delay and latches and all those things will come.
Lordship.
Acquiescence. All those things will
Lordship will do. Lordship.
1 week.
Lordship. After 2 weeks, Lordship, because we'll do the research. It will take time. Again, we ask for her because
so you're also
just now Lordship has saying that justice is that seems to be done. That is very. I just cannot be done it hurriedly because we will go through and then for the better assistant to give better assistance to the court.
Mr. Sangma gets away with things only because of his demeanor. Matter has been heard substantially. However, before the conclusion of the hearing, General Counsel for the petitioner, Mr. P.T. Sangma, has submitted that he may be allowed to amend the prayer of the petition. Prayer in this petition. The submission has been sternly objected to by the respondents. by all the respondents. However, for ends of justice, this court would allow the parties to address this issue on the next date fixed with relevant authorities, if any. As prayed for, this is matter after 2 weeks.
Lordship. Authorised, Lordship.
Item number 9.
May please your lordship, in item number 9, I beg to seek for grant of 2 weeks time, my lord, because the conducting counsel, due to personal difficulty, is not available today.
Your petitioner.
Petitioner.
On pre-made by Mr. S. Sengupta, Merit Additional Senior GA, seeking for accommodation on the ground that the conducting counsel is indisposed. Matter is adjourned. This is the same after 2 weeks.
I'll oblige.
Item number 10.
You are appearing for all the respondent.
Respondent number 1, 2, 3, 4, 4. Respondent number, the affidavit has been filed on 2nd March 2023, and respondent number 2 had entered appearance by filing wakalatnama only on 3rd November 2023. Therefore, the point is that whether the affidavit filed by the respondent number 1 can be relied upon by the respondent number 2.
Well, let him make out his case unnecessarily in the matter.
The notice has been already issued, Lordship.
For
Prima
almost
facie
2 years.
case is
It's a
there.
contempt matter, my lord. Unnecessary contempt is handing over the director of negligence, my lord. So let him make out a case, my lord. If he makes out a case, your lordship will issue a second notice under the Meghalaya High Court rules, my lord. And if he does not make out a case at all, the lordship will dismiss the matter, my lord. So rather than on affidavit, this affidavit, that affidavit, prima facie, one affidavit is there, my lord. Let him make out a case if your lordship is convinced that there is some contempt made out, my lord. Your lordship will issue fresh notice to under the High Court rules, my lord.
In contempt matter, Lordship, the
that would
parties
be
are to
see,
appear.
That would be the
Yes.
procedures.
Yes.
If contempt is made out, notice will be issued. Parties are to appear personally.
Already a notice has already been issued.
No, if
my lord, I think my friend is not aware how the contempt
if contempt is made out.
Lordship, I will start.
I think that's the correct procedure.
My lord. If prima facie case is made out, my lord,
application is filed as supported by affidavit, and notice is issued. That is the notice.
I think my friend has to
and
again
now
go
only
through
the relating to this for sentence, if further court is
my lord,
satisfied.
I think my friend has to go through the Meghalaya High Court rules once again, my lord.
Which clause of the rule he is referring?
You should know like how the content proceedings are taken up, my lord.
So I will start on the argument, Lordship. Now,
please.
Now, Lordship.
Today
is 18.
Yes. By the way, this petitioner is no longer in
No, he had left the institute. He has completed his course.
Please start.
Yeah. Lordship, the petitioner is by profession a doctor, and he had passed his MBBS from Government Medical College, Nagpur, Maharashtra, and then he had sit for the entrance examination, and he had got admission in NIMRIMS in the anatomy department in the year 2013. In 2013, he had joined the anatomy department for pursuing his MD course. Now, what happened, Lordship? From 2015 onward, he had started facing different issues like discrimination, harassment, and torture from the faculties, and then he had to for his safeguard of his life, he had to leave the institute. And in the meantime, there were 3-4 police cases filed by the institute. Now, he is unable to take admission in other institutes and all, and to safeguard his medical this career, he had met several representation to the authorities, higher authorities, constitutional authorities, from president to prime minister and other authorities. Then he had found that he is not getting justice. He had filed a writ petition before this honorable court in the year 2017, which was registered as
Registered as
WPC 61 of 2017. That is at page 8 of the writ petition. 8 and 9.
Yes.
So he had filed the writ petition, and this honorable court was pleased to issue notice upon the respondents, and after hearing the parties, the institute as well as the petitioner, and that case WPC number 61 of 2017, the petitioner had appeared in person, argued the matter, and the honorable court, after hearing at length the parties, had been pleased to dispose of the matter by judgment and order dated 25/7/2017.
That is, sir?
Which is at page number 41 of the writ petition, annexure 1. That has been marked as annexure 1.
Yes.
The operative part is page number 48.
Yes.
May I read, Lordship, the operative part of the judgment?
Yes, please.
Page 48, para number 7. After hearing the submission made by the petitioner in person and Mr. K. Paul, learned CGC, I feel that this matter can be disposed of with the following directions. Number 1. Respondent Ningrim is directed to release the stipend of the petitioner which he is entitled as per rule. Number 2. If petitioner wants to continue his MD course, he should be allowed to do so. Number 3. He should not be discriminated in any manner and nobody should harass him. Number 4. All the FIRs filed against the petitioner are hereby quashed. Number 5. In case the petitioner does not want to pursue further studies and want to leave the university, no adverse remarks should be noted or written in his certificate, as he should be treated at par with the other students without any malicious intention. Petitioner is also directed to maintain peace and harmony, and the respondent are also directed not to disturb the petitioner. Both the parties are to maintain peace and harmony. Now, after this judgment, Lordship, the petitioner stipend of the petitioner was released. Then he had rejoined the institute in the year 2018. 2018 he had joined on 5/3/2018, and he had again been harassed. As such, on 6 March 2018 he had written a complaint to the director. That is at annexure 2, page 50.
Yes.
On 5th, and then on 6th, he was threatened by the respondent number 2, who was the HOD, for rejoining the institute. Hence, he had filed a complaint with the director. And looking at this situation, the then director had deputed a guard specifically to look after him, to specifically look that he is not he is not harassed, or nobody attacks him, or he does his work peacefully, to that in the department. And that was not specific for the petitioner, specifically appointed for the petitioner. It is specifically for in the anatomy department to look after that the petitioner is not harassed, or petitioner does his work peacefully. And thereafter, after rejoining, what he found is that his specimen, those specimen mouse and others items, were stolen. Then he searched in the institute, in the department, and he found all those specimens lying in the room of one of the faculty of that department itself, anatomy department, that is Dr. Sara Ralte, who is an assistant professor in anatomy department. Then he confronted with the said faculty that this specimen belongs to me and you have stolen it. Once it is taken without the knowledge of the person, it is to be termed as a theft only. Therefore, you have committed a theft. Then he had filed a complaint in this connection that my specimen is stolen, and that is done with a malicious intention that my this completion of thesis work is should be jeopardized. And on that complaint, Lordship, it was given to an understanding to the petitioner that some enquiry will be done. But that result of the enquiry till date has not come, is not known to the petitioner. Thereafter, the petitioner...
Where is that complaint?
Complaint is at page 55-56. And that was with enclosures, photography showing bottles in which treated specimen of fetus were preserved for my thesis by me, photograph showing that how Dr. Sara Ralte had stolen my thesis specimen, mice fetus, by over-labeling on my thesis specimen bottles. Photography of showing handwritten labels of Dr. Sara Ralte, which prima facie showing that how she alone had stolen my mice specimen. Now, Lordship, here I will pause a little and draw your Lordship attention to my rejoinder affidavit. After the filing of this complaint, when the enquiry was about to start, the petitioner is in dark whether the enquiry relating to the theft of the specimen is going on or not. In the meantime, what happened? Dr. Sara Ralte had filed a contempt petition before this honorable court against the petitioner, alleging that he had called me thief. He had called me thief and he had lodged a complaint against me. That is a violation of the peace in the department. Now these fact, when the petitioner has filed all this this contempt petition as well as two other writ petitions, that is WPC 417 and 418 2022, after inquiry from the registry, found that there was a contempt case before the petitioner, and in that contempt case no notice was issued. I may take your lordship to the order passed by this honorable court in the contempt petition filed by Dr. Sara Ralte. That is in my rejoinder affidavit at page number 26.
Page
26.
Yes.
Yes, there was an allegation that disobedience of the judgment dated 25/7/2015 rendered in WPC number 61 of 2000 is alleged by the petitioner against the respondent. Respondent is the present petitioner here. Hence the petition for launching contempt proceeding against the respondent. So in the judgment that part has been quoted. Now what is very important and relevant is para number 6. Ningrim seems to have constituted an inquiry committee which has initiated the inquiry. Same is clear from the letter dated 30/6/2018 addressed to the petitioner by the chairman inquiry committee Ningrims. This inquiry is related in pursuance to my complaint that my specimen has been stolen. Faced with the aforesaid letter, the petitioner has filed the instant petition alleging that the respondent has violated the directions contained in the judgment dated 25/7/2017 rendered in WPC number 61 of 2017. In the context of the direction as quoted above, what as on date acts of the respondent amounts to disobedience of the direction shall be premature to comment upon in view of the inquiry initiated by the Ningrims which is in progress. It appears that the letter dated 30/6/2018 addressed to the petitioner by the chairman inquiry committee has prompted the petitioner to file the instant petition with the object of shuttling the inquiry proceedings. The outcome of the inquiry as initiated by Ningrims will provide a cause as to whether direction quoted above in any manner have been violated. At this stage, while going through the record available and for the reason stated herein above, no case for initiating contempt proceeding is made out. This was at the motion stage. The Honorable Court has disposed of the petition. Now, Lordship, the other students of the institute were provided with extension. When they could not complete their thesis in time, they are extended, given extension of 2 months, 3 months, some more times were given. But in the case of the petitioner, such time was not granted and his thesis was not completed. As such, he had sought for some time. And in the meantime, the Ningrims authority has issued a letter to the petitioner asking him to submit the thesis that his course completion time is 31/7/2019 and no further time will be granted. So he had filed a writ petition before this honorable court. He was directed to submit his thesis by 15/10/2019. Then he had filed a writ petition before this Honorable Court that was registered as WPC number 475 of 2019. And that writ petition was disposed of by this Honorable Court by a single bench by order dated 24/11/2021. That order is at page number 57, 58 and 59. So page number 59, second line I may read.
Yes.
He was also advised to submit his thesis latest by 15/10/2017 so that the final university exam could be planned accordingly as it is indicated in the minutes of the said meeting. Having heard the rival submission, I have given my thoughtful consideration to the matter and peruse the matter on record. Already more than 6 years have passed after the start of the course. This court is not inclined to interfere with the impugned order. However, without making any comments on the conduct of the petitioner, this court, taking into consideration the fact that the petitioner had already spent 6 years of his life to the studies, deem it appropriate to direct that if the petitioner submit his thesis by 31/12/2019, the respondent shall accept the same and shall program and hold the final university examination with an intimation to him. It is made clear that if the petitioner fails to avail the direction, he shall be doing so at his own peril. The court places on record its sense of appreciation to Mr. A.H. Hazarika, who has provided pro bono service to the petitioner. Now, Lordship, the Honorable Single Judge had directed the petitioner to submit it. The submission of a thesis is not solely dependent on the candidate or the student. It is also the joint work of the guide. If there is proper guidance, coordination is there, then it would be completed. But in the instant case, there was no coordination from the guide who was hostile against the petitioner. Therefore, anyhow, in compliance to the said judgment order of the Honorable Court, the petitioner has completed from his end the thesis which he was supposed to file by 31/12/2019. He has completed and he had submitted on that day a thesis. But the said order against the petitioner was aggrieved by the said order. Therefore, he had filed a writ appeal.
Why would he be aggrieved?
Huh?
Why would he be aggrieved?
Because Lordship, such a order of fixing the time of submitting the thesis could not be passed in such cases, because submission depends on this upon the
Anyway, whatever the case may be, the matter would have become infructuous on his submission of his thesis on 31st.
After submission. So thesis, the time frame which has been fixed is not
has been adhered with him,
not beneficial for him or not appropriate. Once the thesis completed, it will be, and for that this is our scientific works, Lordship, which a time frame could not be fixed. Because there are.
But in any case, he has done so.
No, I will come to that. He had filed this. Okay. Then what happened? In short, the petitioner was asked by the respondent number 2, who is the HOD as well as guide, to do some test. There are 2 types of tests. So the guide was asking him to conduct another type of test, which the petitioner found that that particular test is not appropriate for conducting and that will not yield a result. And if he continues that, it will result to his non-completion of thesis and he could not complete his course. Therefore, he went to the director. He went to the director for his guidance that I had been advised in such a way by my guide, HOD, that I have to conduct this type of test. So director had said that no, you have to conduct another test which is appropriate and which will yield a result and your thesis will be completed. So these give a rise to the petitioner, these give a rise of doubt in the mind of the petitioner about the competency of the respondent number 2, the guide. And he had written a letter to the guide. Clarify on these 2 points. Without clarifying that points, whether I should go for this test or that test, and about the director, the guide, respondent 2, had admitted whatever advice you are given by the director, that you apply. Those are very valuable guidance. I will come. Then the guide has in the meantime, that thesis which he had submitted on 31st/12/2019 in compliance with the Honorable Court's order was not signed by the guide. So the thesis was rejected by the authorities and said that you have to comply some of the procedure in guidance with your from the guide. On 5/6/2020, the guide, at a period of 6 months has lapsed after the passing or fixing the date, the final date for submission of the thesis. 6 months has passed. 31st/12, 6 months has passed. On 5/6/2020, the guide has tendered her resignation. That is at page 65.
Yes.
So page 65. So here in para 2,
yes,
again, sir, I am informing you in writing that I refuse to continue to be guide of his thesis and to deal with him in any further academic matters, including his MD examination.
So she resigned as guide.
As a guide. So last para. In this regard, if you try to convince me to look after the thesis of Dr. Jaibe, I will consider that it will be a deliberate attempt by you to harass a lady with a serious cardiac condition. As she has given a threatening also that you cannot insist upon me. Thereafter, on 7th August, after a lapse of more than almost 2 months, Lordship, from 5/6, 7, then 8. 7th August 2020, that is at page 67, annexure 8.
Yes.
Dean Ningrims had appointed a new guide for the petitioner for the purpose of completion of his thesis.
Yes.
Now that is page 67.
Yes.
Consequence upon acceptance of the resignation tendered by Dr. Ashima Bhattacharya, Professor and Head, Department of Anatomy, from the guideship of postgraduate thesis in the subject anatomy, with regard to Dr. Jaibhaya Nilesh Kesharao, in the meeting held on 4th August 2020, Dr. Ashamiya is hereby released from the assignment of guideship with immediate effect. Dr. Amitabh Sharma, Associate Professor, Department of Anatomy and co-guide of PG thesis of Dr. Jaibhai Nilesh Keshavrao, is hereby appointed as guide with his due consent with immediate effect. Now, after the appointment of this new guide, in a record period of 20 days, Lordship, the petitioner could complete the thesis, which was not possible in 7 or 8 years when respondent number 2 as a HOD and guide was guiding him for completion of thesis. Then the thesis was completed and it was submitted. The thesis was submitted. After the submission of the thesis, Lordship, the university has fixed the examination routine for the petitioner. Now, when the examination routine was fixed, petitioner has apprehended that he will be harassed in the examination and all means will be adopted by the institute to destroy his career by making false allegations of malpractice in the examination and other allegations. Therefore, he had written a letter to the university, the registrar, Northeastern Hill University, Shillong, on 15 February 2021. What his prayer was to install fully functional CCTV camera in examination hall of final year's university examination of MD Anatomy of first year student MD Dr. Nilesh Jaibhai. First year, no, Lordship, he is the first candidate to pass MD from Ninglips, MD Anatomy.
Yeah, it's a final year.
Yes, it is final year student. To avoid any fake, bogus or orchestrated allegations of cheating, copying, examination misconduct by the authorities. Similar letter was also written to the officer in charge, police station in charge, Maudingdiang police station. So, Lordship, the police has duly intervened into the matter. They have come for an inquiry and they have advised the faculty members and others also that he must not face any harassment in the examination.
Yes. Yes.
Examination, and during the theory examination, Lordship, there was no installation of CC camera. However, at page number 16 of my petition, para number 11, on 8/3/2021 and 9/3/2021, 2 days practical examination was there, and on those 2 days, Lordship,
yes,
there was installation of CC camera. CC camera was installed, and some faculty members were called from other places, other institute.
Yes.
But here the institute has not called the NMC inspector.
Yes.
Which, as per practice in vogue, for any department, whenever the first candidate of a first batch of the candidate who are appearing in the examination, during that time the inspector should come.
But may I intervene, my lord? We are arguing a contempt matter, my lord. My lord, my friends should be concise that whatever the direction which has been violated, my lord. Beating around the bush will not going to help anyone, my lord.
Yes, I was wondering why.
Which is the direction with that has been violated, and whether there is a willful violation and who is violated. It's a very precise matter, my lord. It's a contempt jurisdiction. There is no need to go into the entire story. Who is the inspector? Where CCTV is there? Where are the direction to install CCTV in the order of this honorable court, my lord? Is there a direction to appoint inspector of NMC, my lord?
No.
You should confine yourself.
Why I am
confined to the direction of this
submitting
honorable
all
court,
these
my lord?
facts and everything because they have brought it in their affidavit. All those things has come up. All these things has come up in their affidavit. Therefore, I must argue first, bringing all the facts.
So, which direction has been violated? At least I have
so
not been able to understand till now.
Violation.
Till now, I have not been able to understand which direction has been violated. He should be specific that this was the direction
Then how he
that has
is
been violated.
Representing his client in this case, if he could not understand.
I am
why
not
the affidavit
understanding your petition. That's what I'm saying. I'm not understanding your client's petition, that how he is aggrieved, what is the violation, and which direction has been violated, my lord.
Now I'm coming to those. It is this part is ending up. His examination was conducted. During practical examination, he was faced harassment. After that, what happened, Lordship? There was during those time Corona period was there, and all the students who were there in the station, they were extended. Their course time has been extended, or some are absorbed in the hospitals also as a Corona warrior. That opportunity of Corona warrior was also taken away from him.
Is there any direction to that effect? I don't understand.
There was from the NMC and all, even the government also, that whichever doctors are available, they are to be employed, their services to be taken. So that is also my grievance. Now what happened? He had completed his course, result was declared.
You have to be
I will come to specific.
Specific.
I will,
because you're going to.
I will come.
You're going to events which are not related to the subject matter.
Then what happened, Lordship?
My lord, he has filed a civil suit for recovery of 19 crore rupees damages.
That is what they are crying in all the petitions.
I saw the conduct of the petitioner, my lord. How abusive a man can be, my lord. He's completed his MBBS and he completed his MD. My lord, I saw the language he uses, my lord, against the head of the department, my lord. My lord, I cannot even read those words in the open court, my lord.
Yes. Then his examination result was also declared by the university, and he was provided with he had passed, and he is the first candidate from that anatomy department to pass the MD anatomy course. It is at page 85. A provisional certificate was issued.
Yes.
That he had passed his MD anatomy course conducted by the university. Next is page 86, Lordship. This is the certificate which was issued by the respondent number 2, where an adverse remark was made against the petitioner at para 2 of this. During the period, his character is satisfactory and his conduct was found not to be appropriate and conducive for a PG student. This is the adverse remark which has been given to the petitioner, which is against the judgment and order dated, that is at page 25/7/2017, passed in WPC 61 of 2017.
Yes. Yes.
So by making an adverse remark, Lordship, they have disobeyed and willfully disobeyed the direction contained in page number 48, 5, para number 7, clause number 5. should be treated at par with the other students without any malicious. No adverse remark should be noted or written in his certificates.
Yes.
This is the contempt. He had completed his MD anatomy course from Northeastern Hill University,
Yes.
and when he was about to leave the institute, Lordship, he was given with a certificate that making an adverse remarks. So this is where they have committed the contempt. Then he had written to the director that to quash and set aside the defamatory and character and conduct certificate issued to Dr. Nile to issue fresh. And in that representation dated page number 87, 28, on the next day itself it was written.
Yes.
But that was not considered and no reply was given. Again on 12 February, supplementary statement
Yes.
to support and reminder for petition dated 28 January 2022 was also given, requesting to quash and set aside this dubious and defamatory character certificate and issue him a fresh certificate. That was also not done. Then again the supplementary statement at page 98. We have filed this is the third representation. Third representation he had filed, and more or less it speaks about that quashing of this defamatory character certificate, so that no hurdle is there. Now, and how this certificate was issued, why nothing has been done? When the matter was taken up by the Ministry of Health and Family Welfare, Government of India, then the director had written a letter to the ministry and a copy was also given to the petitioner. Then it could become, petitioner could come to know that a committee was formed before issuing the certificate to him. A committee was formed, that is at page number 122.
Yes.
So here the minute page 123 is the type copy, clear? Now, who was the chairman of the this committee is Dr. A.J. Patwari, who is respondent number 3 in the present contempt petition.
Yes. Yes.
And what is he? He is a HOD, Department of Forensic Science, Postgraduate Examination Controller, and Chairman of Ex-Party Committee, North East Indira Gandhi Ningrims of India. So they have examined the matter. To examine the conduct of Dr. Nilesh K. Jai Bhai, pass out postgraduate students in department of, and first what they have placed before in this committee is that the direction of the Honorable Court pass in WPC number 61 of 2017.
Where is it?
Page 125. This contains two pages, page 1 and 2. So type copy is given in page 125.
Yes.
The direction, I will read the first. After this point number 6, that is, in view of the above direction of the Honorable High Court of Meghalaya, committee unanimously decided not to look into incidents that has occurred prior to the above court verdict. The committee only agreed to examine conducts after rejoining to the course by Dr. Nilesh. The direction of the Honorable High Court of Meghalaya in its judgment in WPC number 475/2019 dated this para 6 was also read out loudly for the information of the which was us under. That already I have read, Lordship. The next, the law officer informed the committee that the date for submission of the thesis was extended by the institute, which was not in violation of the High Court of Meghalaya order in WPC number 475/2019 dated 2011-2019. It was also informed that the same was established in the High Court order in WA number so and so. So here, Lordship, the committee has not given any specific findings.
Yes.
Page 3 is also there, Lordship.
Page 3.
Yes, Lordship. Page 127.
Yes. Yes.
Page 135.
127, you're referring to which part?
127 is a continuation of those, the meeting, proceeding of the meeting. Lordship.
Okay. Then 135.
Committee is committee 133. 133. Under the above circumstances, the committee is of the opinion that
yes,
the conduct of Dr. Nilesh K. Jaibhaye was not appropriate and conducive for a PG students of Ningrim, Shillong.
Yes.
So this has been reflected in the certificate, which is at page 86. And in this committee, Lordship, when any committee is called for, he was never summoned to appear, never given a notice to clarify on anything. This is an ex parte committee. It has given its own finding, and thereafter this character certificate was issued. So how this character certificate was issued, that he had come to know at the later stage. Then he had he continued writing the representation to the authorities, and then he had issued a pleader notice, legal notice, to the respondent number 1 and 2, which is at annexure 27, page number 212.
Yes.
He had issued this on 11th May 2022 through his counsel.
Yes.
and in that the entire case of the petitioner has been narrated from in different paragraphs from 1, 2, 3, all. The important one will be, Lordship, will be para number 11, which is at page number 216.
Yes.
The para number 10, that the grievance of my client for issuance of fresh character certificate with no adverse remark could have been easily considered by the notice receiver number 1 and 2, while my client is an outgoing student and the institute will not be benefited in any manner, tainting my client and damaging his future medical career, which the institute had already damaged around 6 years of my client's valuable medical career. However, notice receivers chose to exercise their power to permanently damage and further destroy the medical career of my client. That the notice receivers could have easily removed the adverse remark and issue a fresh character certificate to my client. Such benevolent act could have rendered justice to my client and save his future medical career. In view of the above facts, I, on behalf of my client, Dr. Nilesh K. Jaibhaye, would like to humbly request the notice receiver number 1, who is director, and notice receiver number 2 is the dean, to issue my client a fresh character certificate with no adverse remarks within a period of 15 days of the receipt of this notice. I have further instruction that if my client was not issued with a fresh character certificate with no adverse remarks within the stipulated time frame, in that event to institute appropriate legal proceeding against the notice receivers, including contempt proceeding. The contents of this notice are in no manner meant to aggravate the situation, but its sole objective is to present the case of my client aforesaid for redressal of his grievance. It is hoped that the notice receivers herein would explicitly give a reasonable consideration on the matters highlighted in this notice in its right perspective and do the needful to salvage my client, Dr. Nilesh K. Jaibhaye, future medical career, who is an outgoing PG student of your esteemed institute. Any reply to this notice may kindly be communicated to the following address. The address of the council was also given. Here is specifically said that contempt proceeding would also be initiated, but they remained silent, meaning thereby they admit all the contention made in the notice. No reply was given, and a copy of this notice was also sent to the Secretary, Government of India, Ministry of Health and Family Welfare, Registrar Ningrims, and other authorities of the Ningrims. Now, when this contempt proceeding was going on, the respondent number 1 had filed affidavit. In para number 2, Lordship, I draw to the Lordship attention to para number 2 of the affidavit. Para number 2. That the deponent at the outset must humbly submit, page 2, yes. Para 2.
Yes, please.
That the deponent at the outset must humbly submit that the deponent has the highest regard for the majesty of law and the orders passed by this honorable court. The deponent has no intention to disobey the order passed by this honorable court, and if it deems so, the deponent tender his unconditional apology before this honorable court. meaning thereby no intention to disobey. That means there is an admission that there is a disobedience. It could be read in this manner, which I have already stated in my affidavit, rejoinder affidavit, that the deponent has no intention to disobey the order.
I think my friend has sufficient number of years of practice, my lord. This kind of situation.
Anyway, you'll get your sorry, you'll get your opportunity to reply. Let him have his say.
Yes. So it is a clear case of admission, and therefore there is a tender of unconditional apology has been tendered before the Honorable Court.
What does it,
similarly?
What does it say? Huh? And if it is deemed so, so it means that it is always in the contingent mode.
Contingent mode. Right. My point is here that they could not sail in two boats at one time. Once here they tender unconditional apology, other side they defend it, and your lordship will see that the order is clear that when he leaves the university, when he leaves, one student will leave a university. I can be a student of A, B, C college. When I pass, I leave the university. In this instant case, he may be a student of the university, but he passed from the university. And when he leaves the university, at that time this adverse remarks, and the order is specifically clear that when he do not want to pursue, if the institute do not provide for PhD in anatomy, how can I remain in that? Either I get the job or there is no further course in the university. Therefore I leave the university. So here the petitioner leaves the university. At that time no adverse remark should be made. This is the specific order of this Honorable Court, which they have violated. And para number 22 also same, lordship, of the affidavit. In the same line.
What does it say?
Same. If there is no violation, they defend it. The deponent stated that the deponent has the highest regard of the majesty of law and the orders passed by the Honorable Court, and have never had any intention of disobeying willfully or otherwise the order passed by this Honorable Court, and if it is deemed so, the deponent tenders unconditional apology. There is a clear violation of this Honorable Court's order, and therefore they have tendered unconditional apology. And lordship, this is clear from the pleader notice, which I have just read, that contempt proceeding, and there was no defense at all. And there was no defense as well as no answers to, no reply was given. Defending that we have not done, it was your client's conduct which was good or bad. So lordship, here the rejoinder in para number para number 5.
Rejoinder. Where's your rejoinder?
Rejoinder is
See, Mr. Padia.
Yes.
What could be understood is this: that the issuance of the character certificate according to you, is a violation of this court's order,
Lordship.
particularly para 5.
Yes, 5. Clause 5.
Clause 5, or para, whatever. So the respondent have to defend that stand.
Lordship.
That's all. If a case of contempt is made out, if we can see that the character certificate was passed within the parameter of this court's order, that clause 5 you said, then there's no contempt. If not, there is contempt. Simple as that.
This was not in
not in consonant with the
yes, Lordship.
Fair.
And therefore a prima facie case of contempt lies against the respondent's Lordship.
We'll continue in the second half, Dr. Musika.
Second half.
Lordship.
$215.
Lordship.
call item number 10.
Yes.
My lord, if I may draw your lordship attention to the order passed by this honorable court, my lord, for which contempt has been alleged, my lord. Page 48 of the petition, my lord, is the order, my lord, operative part.
Yes.
I'll read para 7 once again, my lord. And what is the purport of this order? What can be the meaning of this order, my lord?
Yes.
After hearing the submissions made by the petitioner in person and Mr. K. Paul on its CGC, I feel that this matter can be disposed of with the following directions. Respondent Nigrims is directed to release the stipend of the petitioner which he is entitled as per rules. It is an admitted position, the stipend has been released, my lord. Now, my lord, if the petitioners want to continue his MD course, my lord, this was the situation when he was continuing his MD course, my lord. He was undergoing the course, my lord. So the question was, if he wants to continue, he'll be allowed to continue, my lord. Third direction is, he should not be discriminated in any manner and nobody should harass him. All the FIRs filed against the petitioner are hereby quashed. Now the next clause, my lord, which is the most relevant here. In case the petitioner does not want to pursue further studies and wants to leave this university, my lord, this I am in contradistinction to second direction, my lord. Second direction, if the petitioner wants to continue his MD course, he should be allowed to. So if he wanted to continue, he will be allowed to do. If he wanted to leave the university, my lord, then the direction is, in case the petitioner does not want to pursue further studies and wants to leave the university, no adverse remarks should be noted or written in his certificate, and he should be treated at par with the other students without any malicious intention. So, my lord, this direction is applicable in case he chose to leave the university at that point of time, my lord. But he did not choose to leave the university, my lord. So, in my humble submission, clause 5 is not applicable at all. What is applicable is clause 2, my lord. If the petitioner wants to continue his MD, he'll be allowed to do so. That he has been allowed to do, my lord, and he has been given the certificate, completion certificate, which our friend has pointed out. So, my lord, in my humble submission, clause 2 and 5 are exclusive. Clause 2 is applicable if he wanted to continue. Clause 5 was applicable only if he wanted to leave the university, my lord. If he wanted to leave MD course in Nigrims and want to go and take admission somewhere else, then to facilitate that so that his admission is not affected, direction was given that in that case no adverse interest would be recorded in his character, my lord. Now here he chose to continue, my lord. So clause 2 is applicable, clause 5 will not be applicable. Otherwise also, my lord, a student, and that cannot be the meaning of the order passed by this. If a student continues to study, my lord, he has to be through the jurisdiction of the discipline of the university, my lord. He cannot go scot-free after doing all kind of nuisance in the university, my lord. My lord, I'll take your lordship to the conduct of the petitioner, my lord. Lordship, you kindly come to my affidavit, my lord.
Yes.
Well, page 25 is one complaint written by him, my lord, in my affidavit.
Yes. Page 25.
25, my lord. My lord, this is dated 17 May 2020.
Yes.
This is addressed to the head of the Department of Anatomy Nigrims through proper channel. This letter contains 9 pages. Subject so and so. First,
Yes.
why I submitted alleged incomplete thesis as per court judgment dated 2011-19 for writ petition of Meghalaya High Court. Second, to tell you, my lords, kindly see the language. I know that husbandless, mouse thief, Dr. Sara Ralte, assistant professor, since August 19, forcing you to not let complete my thesis either by non-cooperation or by adding some wrong correction in thesis to let it automatically be rejected. Third, to curse Brahmin caste, anesthesia HOD Mr. Prithvi Bhattacharya for his possible evil intervention in completion of my thesis, as like Dr. Sara Ralte, with his Brahmin mania existing in his empty skull against SC, ST, OBC caste people in Nigrims and everywhere. To ask you to provide in writing that for 4 groups of my thesis there is you need to apply pair test and not ANOVA test as so and so. Now kindly come to 6th, my lord. To tell you in writing that I am fed up of Brahmin gangism and India non-India nonsense of anatomy department run by you, and that husbandless mouse thief Dr. Sara Ralte, assistant professor, so had since last 2 years had not gone to my home and I am not interested in so and so, so and so. And this is the kind of language he is using, my lord. And he wants a clean chit, a good behavior certificate, my lord. My lord, next page, my lord, kindly come, page 27. Subject heading number 2, the 4th paragraph, my lord. Subject heading 2, I know that husbandless mouse thief, Dr. Sara Ralte, since August 2019, forcing you to not let complete my thesis either by non-cooperation or by adding some wrong correctness, so and so, so and so.
Yes.
Page 28 now, my lord. Some are in Hindi, some are in English. Now I will surely file legal complaint against this anti-India, husbandless, mouse thief, Dr. Sara Ralte, for unnecessarily interfering into my thesis work, even after harassing, torturing and filing fake police case of self-styled sexual assault. Then, my lord, as because otherwise without evil interference of Sara Ralte, though I would have already completed and submitted thesis for before 17 January as per MCA rules. Subject heading 3rd, to curse Brahmin caste anesthesia HOD Dr. Prithvi Bhattacharya for his possible evil intervention in completion of my thesis, as like mouse thief so and so, so and so, so and so. Now, page 29, your lordship, kindly come.
Yes.
My lord, this is in Hindi, my lord. I'll just try to translate and I think my friend will agree.
You are reading?
Page 29, my lord.
Which part? This
3rd para, my lord. This is in Hindi.
Hindi, yes.
मैं भी उसको बद्दुआ देता हूँ कि उसकी प्रेग्नेंट बेटी का बच्चा पेट में ही मर जाए. मतलब I curse Dr. Prithvi Bhattacharya that his pregnant daughter's child dies in the womb. And his pregnant daughter's labor ward, there is so much bleeding in her labor ward, so that she has to undergo urectomy. And this is how I curse Dr. Prithvi Bhattacharya, my lord. Then he says, my lord, Brahman Mr. Prithvi Bhattacharya, daughter should become widow, should beg in the street. My lord, he's a student of a master's in medicine, my lord, in the university. Next page, page 30, lords will again see a husbandless mouse thief, Dr. Sara Ralte. Third paragraph. On page 31, my lord. Subject heading 6th, towards the bottom, my lord.
Yes.
Subject heading 6, to tell you in writing that I am fed up of Brahmin gangism and India non-India nonsense of anatomy department.
That he has stated earlier also.
My lord. Here he says, my lord, I am fed up of Brahmin gangism in India, non-India nonsense of anatomy department run by you and that husbandless mouse thief, Dr. Sara Ralte, has since last 2 years, March 2018, I had not gone to my home and I am not interested in fighting with any criminal-minded person Nigrims for any reason. Then in the next page, my lord, page 32. when I see shameless faces of Sara Ralte, Prithvi Bhattacharya like people in Nigrim, then I feel as like I am opening door of ugly smelling public toilets. This much disgusting and pathetic I feel.
Yes.
So, my lord, this abusive language of this, my lord, was taken into a committee was constituted. My friend has taken a lordship, and this committee, after going through, has given a clean sheet in as far as character is concerned. But as far as his conduct is concerned, my lord, they have said that his conduct is unbecoming of a student of MD. My lord, if lordship permits, I can take your lordship to the report, my lord. My lord, I'll take your lordship directly to the operative part, page 50, my lord, of my affidavit.
Page 50.
Page 50. The committee is of the opinion that, lords will see. Page 50, my lord.
Yes.
Some in the middle. The letters written by Dr. Nilesh K. Jayabhai contain abusive word against a particular community as well as derogatory comments against a few faculty of Nigrims, out of which 2 are female faculty. He also used wrong words against the daughter of the HOD anatomy. By writing the abusive and provocative remarks, Dr. Nilesh Jayabhai has disturbed the peace and tranquility in the institute, though the Honorable High Court of Meghalaya in the judgment dated so-and-so, dated 25/7/17, clearly mentioned that the petitioner is also directed to maintain peace and harmony, and the respondent are also directed not to disturb the petitioner. Both the parties are to maintain peace and harmony. The abusive words used by Dr. Nilesh K. Jayabhai against the HOD anatomy, the assistant professor anatomy, as well as the daughter of HOD anatomy are violation of cause of the code of conduct of students as mentioned above. Any practice, whether verbal or otherwise, derogatory to women. The abusive word used by Mr. Nilesh Jayabhai against a particular community is violation of Clause G of the Code of Conduct of Students as mentioned above, creating ill will or intolerance or religious or communal grounds. Under the circumstances, the committee is of opinion that the conduct of Dr. Nilesh Jayabhai was not appropriate and conducive for a PG student of Nigrims, Shillong. So, my lord, based on the, and this was a 4-member committee, my lord. And none of the members against whom he has some problem, my lord. They are the members of this committee. These are independent members, my lord. B. Rinja, Dr. Sobhami Chakravarti, A.J. Patwari, Chairman, E. Jiten Singh, member. Now, my lord, these contempt proceedings are for what? He must cite that this particular clause has been violated. And he must also show that he has not violated any clause, my lord. My lord, this will clearly establish that the direction that both parties would maintain peace and harmony. There's a clear violation on his part, firstly, my lord. Secondly, my lord, the direction not to enter any adverse entry was only in case he chose to leave the university at that point of time. Since he invoked clause 2 and continued and has completed his MD in the university, my lord, after completing the MD, he has already left the university. So clause 5 will not be applicable, my lord. Clause 2 will be applicable, and in clause 2 there is no such clause that, and my lord, in any case, no student can be given a blanket license that he can come and abuse anyone in the university, my lord. My lord has seen the kind of language he is using, my lord. He is not only cursing or abusing the HOD, my lord, even he is abusing and cursing the daughter, who has nothing to do with the Nigrims, my lord. And abusing that her child should die in the womb, she should have profuse bleeding, and she should undergo all those kind of things. She should beg in the street. My lord, this is, in my humble service, absolutely unbecoming of a MD student, my lord. People look up to MD student of a premier institute like Nigrims, my lord. So, in my humble submission, my lord, no contempt is made out. Moreover, my lord, he has filed a civil suit, my lord, for recovery of 19 crore rupees from Nigrims. That we have stated in our affidavit, my lord. And that suit is still pending. So, my lord, he has come here to pursue his study, or he has some different intentions, or we do not know. But as a bona fide student, if he was a bona fide student, there are the hundreds and thousands of students. No problem has happened with any of the students, my lord.
Yes, that's about it.
My lord.
What is your reply, sir?
Please, Lordship. As I have said, Lordship, the direction is relating to when he leaves the university. I have given the example, Lordship. ABC can, one can be a student of ABC Institute. Here the word institute is not there. Had it been institute, my contempt does not lie when he leaves the university or institute. Here the university, in two circumstances the university students leaves.
Yeah,
and there is no no occasion for leaving the university.
University.
There is no occasion. If he leaves the institute, there is no point of leaving the university.
No, this university refers to which?
University means Northeastern Hill University. Oh. Because I will get a degree from Northeastern Hill University. And that is from the provisional certificate.
Institute of Nigrims, my lord.
No.
Affiliating university can be, university can
so
be.
So university, one leaves the university. University gives the migration certificate. University gives the pass certificates.
See, Mr. Paria, you are.
So, Lordship, this is here. And there is a clear violation.
You are complicating the issue. You see, he is a student, or rather he was the student of the institute.
Yes.
Of Nigrims. Nigrims may be affiliated to NEHU as far as the degree is concerned. If he leaves the university, he first has to leave the institute. What is the purpose of him leaving the institute?
If I leave the institute, there is no requirement of character certificates also. Then the issue of certificate does not come into picture. I leave the institute, Why the institute will give that he had left the institute? No certificate. Issue of certificate does not come on that.
My lord, that is from where is that a pleading?
Now
my lord, after leaving any institution, we need a certificate of character certificate after leaving the institution. There is no certificate required while I am still in the school or college.
I leave it incomplete, then I do not need. I may join any institute for LLM for first semester or second semester. I leave the institute. I can leave anytime, and I do not need any certificate. Institute will not give any certificate. So here the university words, because his lordship then could foresee that this petitioner has stood against a mighty institute, he will have to face the consequence at the future end. This is how the entire student communities were terrorized in all over India, and thousands of students are dying also. Those who could not fight with this type of atrocities. Then I'm giving a general submission, and this is how lordship has come into various platform also. So here the university's quote is very clear that when he leaves the university, in what circumstances leave the university is that one pass the university, then only pass the exam, then leaves the university. So here there is a clear violation, and this has been time and again he had brought it to the notice of the authorities that this has, and finally that he is unheard. They are not responding in any manner. Then finally he had taken resorts to come to his counsel for issuance of a notice.
Where is the that certificate?
Certificate is at page number 486. and what has been submitted is that he had used abusive language. Is there any inquiry over it? Was there any complaint against him when he was a student at that time, appropriate point of time taking action against him? Was any show cause issued to him asking that how you have used this language? Those are all subjects to inquiry. That was not done. All of a sudden, when he passed, after that, such inquiry was conducted, that is also behind his back. He was not called. Had it been called, then he could have given an explanation. He was not called, and then this certificate was issued, which is clear violation of this Honorable Court's order. I will rely upon one decision, Lordship, of Honorable Supreme Court. This decision is very recent, passed on 6 September 2023.
Yes.
Lordship.
What is?
Para 40, Lordship.
40?
40.
Yes.
Yes, para 4. The object of the discipline enforced by the court in case of contempt or of court is not to vindicate the dignity of the court or the person of the judge, but to prevent undue interference with the administration of justice. And para 43, Lordship. The following condition must be satisfied before a person can be held to have committed civil contempt. There must be a judgment, decree, direction, order, writ, or other process of a court. There must be disobedience to such judgment, decree, or direction, order, writ, or other process of a court, and such disobedience of the judgment, decree, direction, order, writ, or other process of a court must be willful. In this case, Lordship, there is a willful. They know it, and this has been reminded from time to time. And there was no response that no, your conduct was wrong. Such type of this. Otherwise, the pleadings would have changed. Then other proceedings would have taken place. Nothing. He remained silent. Not bothered to even reply the pleader legal notice also. And the language was humble. My client's language may be harsh, but my language was humble.
Naturally. You see, if the counsel's language is,
then it was stated also at para number this.
Apart with what the petitioner has written, then that would be unthinkable.
Then it was also.
Yeah, I've heard enough. I'll pass this yours.
Lordship, and then Lordship, the para 50, 56, 98 also very important.
Lordship. I'll pass my order.
Lordship.
The court has made up its mind. I will dismiss your petition with cause. At least you can go and appeal and see what the division bench says. Order reserve. Sure. This kind of language cannot be tolerated.
For that, Lordship, I will say that.
You see, you read the impugn order. You read the judgment of this court. Not only para 5. It has to be in consonant with para 6.
2 and 5.
That page 48.
Page 48.
Para
Yes,
7,
Lordship.
6, 5 and 6. Yeah, they have to be read in consonant. Right. 2 hands is required to clap. So you cannot just listen to one side and ignore the other side.
And then what?
The conduct of a client is not becoming of an MD student. Now he is pursuing his PhD.
No, he had not till now.
Thank you.
not sure. Always kept in. Always kept in a plug.